Again, please make sure all cell phones are off or on vibrate. Court, all rise. Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within upon the Commonwealth. Draw near, give attendance, and you shall be heard. Now say the Commonwealth and Masters. Court is open. Please be seated.
Good morning and welcome to this session of the Massachusetts Appeals Court. It is my great pleasure to be sitting today with Justices Henry, who is on my right, and Justice Hershfang, who is on my left. And my name is Gabrielle Wolohojian. I'm going to cover a couple of ground rules first before we reach the first case. Each side receives 15 minutes for argument. There is no rebuttal in the appeals court. The yellow light on the podium will go on when you have a minute and a half left for argument, so that you have fair warning that you need to wrap up a minute and a half later. When the red light goes off, your time has expired. If you plan to split your time in argument, please let us know ahead of time so that we can set the clock appropriately. You may assume that we have read your briefs and most, if not all, of the pertinent parts of the record. So you may construct your argument in any way you'd like, but you don't need to feel like you need to educate us on what your case is about, because we have read those materials. So you can jump right into the meat of your argument without worrying about telling us the background. With that, I am going to call the first case, which is 2022P 0083, Commonwealth versus Eddie Robles, if I pronounce that correctly. And Attorney Magiacomo, did I pronounce that correctly?
Close, Magiacomo.
Magiacomo, sorry about that.
No worries.
We're ready whenever you are.
Thank you. Please the court, just for the record, Joseph Magiacomo on behalf of Eddie, I believe, Robles. Anyways, I'd like to first address the motion to suppress. And as you know from reading the brief, I believe that the court erred in its suppression of the evidence that was seized from the motor vehicle stop. I think the court has to realize that first and foremost, as we all know, that the stop must be reasonable under the 14th Amendment. In the case of Barr, there was no traffic stop. It's evident from the testimony that the vehicle was targeted because there was a belief that Mr. Robles was in the vehicle. That being said, I would suggest to the court that there was no evidence presented that Eddie was driving the vehicle. So in and of itself, the fact that there was I'll be polite and term it as a miscommunication as to whether Eddie's license was suspended or not.
Well, can you explain that? Because it seems like we have a finding from the judge that the license was suspended.
The testimony was that, my recollection of the testimony, Justice Henry, was that the sergeant involved was back at the station, allegedly ran Robles' license and radioed that his license was suspended. Now, subsequent to that, during trial, it was revealed by defense counsel that at the time, Mr. Robles' license was not suspended.
Okay, but when we're assessing the motion to suppress, we assess it based on the evidence that was before the judge then, correct? Not what was elicited at trial.
Correct.
Okay, so at the evidence at the motion to suppress was that the officers were informed that the defendant's license had been suspended.
Correct.
So if they saw him operating a vehicle with a suspended license, well, with what they thought was a suspended license, they would be able to stop the vehicle, correct?
If they had seen Mr. Robles enter the driver's side of the vehicle. There was more than one individual that entered the vehicle. In
I
fact,
thought
my
there was
recollection-
testimony at the motion to suppress hearing that he was the driver.
My recollection of the facts, Justice, is that there was no testimony pertaining to who actually was the driver of the vehicle, that Robles had entered the driver's side.
Okay, so what do you do with the fact that the testimony at the motion to suppress hearing was that the police did not pull the car over, but rather that the operator of the car pulled the car, just stopped?
Well, as you know, and as the case law holds, yes, the vehicle stopped, but once the unmarked police vehicle pulled behind it and illuminated its emergency lights, that is a seizure in Massachusetts. And I would suggest to the court at that point in time, the seizure had initiated.
So if a car is pulled over, let's say, in a breakdown lane, and a police car pulls behind that car, turns on its lights, let's just say as a safety precaution, which often happens on the highway, your view is that that's an event of constitutional magnitude? That's a
Yes,
stop
and-
of constitutional magnitude?
Not only that, but I would suggest to the court in this case, it cannot be read that way. There can be no dispute that Robles was a target. There can be no dispute that that car in general was a target. They started following the car because of the pending search warrant. And the fact that they followed the car 100 yards, 300 feet, 100 yards, again, a football field. And when the car pulled over, there was no indication that there was anything wrong with the car, that there was a distress. When they pulled over behind it and initiated the activation of the emergency lights, their subjective intent can be read that they were wanting to detain the occupants, specifically Mr. Robles, because of the search warrant.
So the Commonwealth versus Charo, which the Commonwealth cited, although not for this proposition, basically says you can't stop him and search him because of the search warrant, because he's not at his apartment, which is what the search warrant was for, but if the affidavit in support of the search warrant provides probable cause, you can stop him, the police can stop him and arrest him away from the apartment.
I would suggest to the court that the case law with reference to that is my plain wording up in the air. If you look at the district, if you look at some of the circuit courts, which I've cited, and I'm sure you took a look at, United States v. Edwards, 10th Circuit, 3 blocks was found to be unconstitutional. United States v. Sherrill, 8th Circuit, 1 block was found to be.
Right, but those are all under the search warrant. They don't deal with the separate question of whether the police still had probable cause to stop and arrest him based on the 3 controlled buys and other observations.
Just a felony arrest, in other words.
They could have done that at any point in time. Those were done in April 6th, 9th, and 10th. And I think the subjective intent is clear here, because if they had wanted to arrest him at any time because of the
Not
controlled
required
buys,
to, they're not required to arrest as soon as possible, correct?
they're not required to
Right,
arrest.
so they know that he's sold drugs on 3 occasions in controlled buys. And then they see him leave the house one day, and they were like, okay, we're going to arrest him now.
Well, Your Honor, I would suggest to you that it's not that plain and simple. The facts are, and as evidenced in the testimony, that they were set up before. So they saw Robles.
What was set up before?
They saw Robles pull into the parking lot. They saw Robles and the other 2 individuals go up into the apartment. This was all seen by Keating and relayed to the other officers.
I know, but we just agreed that they don't have to, the police do not need to arrest someone as soon as possible.
Right.
So if that proposition is true, what happens to your argument?
Nothing, because I believe the facts show that the subjective intent of the officers was to arrest him because he was leaving the scene, and the arrest was predicated on the search warrant, that they could detain him while they searched.
Do we
If it was
use their
predicated-
subjective intent, or do we look at the objective grounds for stopping and arresting him?
I'm sorry, I
Do
couldn't.
we use subjective intent, or do we look at an objective standard for whether they had grounds to arrest?
I would suggest to the court that you have to look at the entire picture in this case.
That was not Justice Henry's question. Justice Henry's question was, do we look at the objective bases for arresting the defendant, or do we look at the subjective intent of the police?
I would suggest that the court has to look at the subjective
All
intent.
right, what's your best case for that proposition?
There is none, Your Honor.
Okay.
We may be making
So
new
let's
case law,
assume
but
that
it's not here.
let's assume that the answer is that it's an objective basis. All right, because the contrary rule would be that the police say, oh, I believed I could arrest him, when they have no objective basis to support that subjective belief.
Why did they not arrest him when he was going into the apartment?
Again, we don't answer the questions here. It's a different kind of system.
I'm not suggesting you answer the questions, Your Honor. I'm merely countering your argument, in that your argument seems to be that they could have arrested him at any time, and therefore the stop should stand.
Well,
But if you...
do you have a case that says they're required to arrest as soon as possible?
No.
Okay. And you don't have a case that says that we look to the officer's subjective intent?
No.
Do you challenge whether the affidavit in support of the search warrant established probable cause to arrest the defendant?
There is I would suggest to you that there is no, I would have to say no. There is a timeliness issue in and of itself, but the 3 controlled buys in and of themselves do support probable cause for an arrest.
How long before the arrest, what was the time gap between the 3 controlled buys and the arrest? The controlled buys took place in April,
April.
and the arrest took place when?
April 11th,
April.
right?
Yes.
So the most recent controlled buy was 2 days before the arrest.
Yes. Well, the last controlled buy was
The 9th.
6th, 9th, and 10th. So it would be
1 day
one
before.
more.
Yeah, I don't, if you don't mind, I'm very curious about your park, the distance to the park argument. So if you don't mind turning to that, I'd appreciate it.
There were two arguments with reference to that. The first argument was the distance, which I will address, and the second argument, I think, has already been handled in Commonwealth v. Peterson. With reference to the first, I would suggest that the officers did not have sufficient information as to the boundaries of the park. There was no testimony pertaining to whether the officer who actually did the measurement did any sort of research as to the boundary, so as to, excuse me, so as to make a determination for the measurement. There also was no testimony as to
Well, he
whether
said he
was a
measured it
straight-
to the fence.
What he assumed was a boundary.
He said the fence of the park.
He did, but again,
Okay.
there was no supporting evidence. He was challenged on that, and there was no supporting evidence.
I read his cross-examination, and there was no cross-examination of the officer on the subject of the boundaries or the measurement.
My recollection, Judge, was that there was, so
Okay,
I may be in error.
maybe I
but
can take-
Either way,
Let me ask a different question, if I may. There was only one school zone / park enhancement, right? And that was count 2, and it was on the trafficking of heroin. It was attached to the heroin count.
yes.
Was that based on the heroin found on his person when he was taken from the car?
I would suggest that it was, Judge.
All right, I don't know about suggest. Was it or was it not?
It wasn't clear.
It wasn't clear?
Within the record as to what one it was.
Okay, if it was for the was there heroin found in the house?
There were narcotics found in the house.
Was there heroin found in the house?
I'm sorry, Judge, I cannot recall that.
Okay, because to my mind, if that charge is based on what is found in the house, then the measurement is from the house to the park, and the testimony was that the house abutted the park.
Yes.
If the charge is based on the drugs found on his person, then the measurement, I suppose, is what? What would you say would be the appropriate measurement if the drugs are based on what was on his person?
Would be the location of the vehicle to the park.
To the park, okay.
And to clarify, Judge, I'm not being evasive or unprepared, they reference a brown substance seized in the apartment. I know now my heroin is brown, so I'm going to assume it was, but I don't recall the exact testimony at this time.
He also sold heroin out of the apartment in at least one of the controlled buys, right?
Yes.
But I don't believe, unless I'm mistaken, that there was a charge for any of the controlled
No, there
buys.
was not. No, and whether the charge was possession with the intent within the school zone. And I think the court would be splitting hairs if they're saying, if they're following the Peterson rationale of someone driving by cannot be, but if, in fact, someone living within 100 yards can be.
Okay, we're going to have to leave it there, because, let me see if there are any other
Thank you.
questions.
Oh, yeah, just one question. You cited to quote exhibits in your brief, but I don't see very many exhibits, so I'm unclear we have them all. Do you know?
They were submitted. I will resubmit them. The exhibits were, every time that something is entered into evidence, I quote it as an exhibit in case the court wants to go back, but a lot of those things are not incorporated into the appendix because
We'll let you
they're
know
not.
if there's something we're missing in particular.
They're not really relevant per se. It's more for a factual basis so that
That's
the
fine.
appeals court can keep track of, oh, okay, that was exhibit in case you want to reference it down the line.
Okay, thank you.
You're
And just
welcome.
for your information in the future, We don't have access to trial exhibits unless the parties submit them in the record appendix.
I was under the
Okay,
impression
that's
that
right.
they
All right,
were
no
sent
problem.
also with the transcript. Thank you.
Attorney Marvel?
Yes.
Marvel?
Good
Okay.
morning. If it may please the court, Elizabeth Mello Marvel for the Commonwealth. If it is all right with the panel, I would like to start with the park school zone issue that was just being discussed. It's the Commonwealth's understanding that the heroin was found on the person.
So the
which
charge
means
was based on the heroin found on the
that
defendant.
is my understanding
All
of
right, that's what I thought.
review of the
That's-
record.
That's what I thought too. So then the question becomes, at that moment in time, is the charge is trafficking, correct?
Correct.
And the elements of trafficking are just possession over a certain amount? Or do you need an intent to distribute?
I believe you need an intent to distribute.
Okay, so, and so all of that needs to occur at a specific location, and that specific location is the point from which you measure the boundary to the park, correct?
Correct.
All right, so I really didn't see any evidence of the intent to distribute at the point where the car pulled over to stop. Can you explain to me how we get there?
Yes, Your Honor. In looking at the testimony that was before the fact finders, the information that they had was that found on the person were, in addition to in the coat pocket there being heroin, there was another smaller bag of brown powder perceived to be heroin. There was additional narcotics, off-white rock-like substance in the right front pocket. There was a digital scale in another pocket. There was another cigarette pack that had 2 additional bags of what was believed to be cocaine. And then there was the cash. These are all factors that were discussed in addition to the testimony in regards to what was found at the home in regards to distribution versus individual use.
Right,
There was
but
no drug
you-
paraphernalia
But
on
all
his-
of that stuff was on him when he left the house,
Correct.
as far as we can tell. What makes the inference that he was going to distribute there 100 feet from the house?
Your Honor, I believe it's the information from the trooper testifying about individuals who only use and what they typically have on them versus
but
what
I'm
you-
trying to get at the question of, is he just on his way to sell someplace?
I don't know that's speculative. I don't know
Well,
that
but
we
that
can speak to
throws
that.
you into the case that says it's not enough to just be passing through. So I'm trying to get at, in this case, how did the Commonwealth prove beyond a reasonable doubt that the point of distribution was where that car was stopped?
He had, I think, if I'm understanding the record correctly, is that he had just left the home, presumably with these items from the home, was about 15 feet from the home, was still on Oak Street, which the testimony from the Parks Department person was that it runs, I believe his wording was, right through the middle of the park. So it's not just adjacent to the park, but going through it. And that he had just left the home with all of those items on him, presumably, again, more indicia of the trafficking. I don't think there's
I don't quarrel with the sufficiency of the evidence that there was an intent to distribute somewhere. It feels to me that the question is, was there evidence that he intended to distribute there at that point where the car pulled over?
I don't know that.
Okay, so if that's the case, how do you distinguish this from Peterson?
I apologize, Your Honor. I don't know that I can.
So.
off the top of my head.
Right. I mean, that's what bothers me about the measurement, because if you don't have evidence that he was intending to distribute at that point where the car was pulled over, then what relevance does it have that you measure from that point to the park? There's clearly evidence of distribution from the apartment, but that wasn't what the charge was based on.
Correct, and the reason why I say I don't believe that that's what the charge was based on, though I'm not certain, is that when there was testimony about what was found in the home, they do reference the off-white and off-brown residue, and they also reference the white bowl that had residue, which tested positive for cocaine, but not necessarily heroin. That's what led me to believe that presumably, I don't think in the record it was distinguished per se, but in looking at what was found and where it was found, that's what led me to that conclusion. But I honestly cannot point to a page, a transcript number or a page and say this is where it was clarified.
It looked to me like it was based on, everyone was trying the case based on what was on his person, because all of the charges, I mean, I don't know, what about count 3, the possession of the cocaine, which was not attached, well, no, that had also a park.
It had, and it was dismissed. I believe that was count 4, if I remember correctly. It was dismissed. There was some error
Okay.
in that.
So what was count 3?
Count,
I thought that was count 3, but
No.
I'm no doubt wrong. So count 3 is possession of cocaine with the intent to distribute.
correct.
Then count 4 was the indictment, possession cocaine with intent to distribute in a park zone, park zone.
Correct.
That
And that was
one-
the count that was dismissed, count
Right.
4.
But count 3, there was a conviction on,
Correct,
possession with intent.
correct.
Was that based on the cocaine that was on his person?
I do not know the answer to that. Again, for the same reasons as we just discussed, the record is not clear, and I don't know if my sister, ADA Anderson, who actually wrote and submitted the brief, I don't recall her distinguishing, she has since retired, I don't recall her making a distinguishing either. So in my review of the record and her interpretation of it as well as submitted in her brief, I don't know that that was clarified, in all honesty.
The trazodone was located in the house, the pills?
The pills, I believe so, yes. There was the trazodone and the 29 tablets of trazodone and the 2 tablets of alprazolam.
Right, so I inferred that counts 1 and 3 were based on drugs found on the person, because the only testimony at trial, because they were both attached to park zone enhancements, and the only testimony at trial about the park zone and how far it was from, and the measurement was from the car.
Correct.
So I backed my way into the idea, well, then the charge must have been based on what was on his person.
Correct. They
Okay.
measured, the testimony was the traffic stop to the park was 25 feet via measurement wheel, and the vehicle to 502 Oak Street was 15 feet via the wheel. I remember the testimony
If we were
correctly.
to conclude that the Commonwealth had, that we can't distinguish Peterson from this case, is it just the park zone enhancement that gets thrown out?
I would say yes. I would say there was still enough information in front of the fact finder in regards to everything found on his person, as well as
Including the
everything found at
intent
the
to
house.
distribute, so all that's missing is proof that that was the location where the distribution was to take place.
Correct.
Thank you, it's been very helpful. Thank you for answering my questions.
Thank you.
So I'd like to switch gears to stop and search of the defendant, are you contending that the search warrant meant that the police could search him even away from the apartment?
Yes, Your Honor.
What's your best case for that?
Well, Your Honor, I guess I would distinguish it from the case Crank, which I know was cited by my brother in regards to searching an individual away from the residence or the site of the search warrant. The reason that it was different is because there was a finding in this particular search warrant, unlike the case in Crank, that specifically spelled out on his person. Not on his person at a particular location, but on his person. It was written in, and that was something that the motion judge did find as well.
Commonwealth versus Charo says, no, you can't just search the defendant anytime, anywhere based on that search warrant that also lists the defendant's person.
However, we also had a search incident to arrest.
Right.
On
and so
two
here-
different.
Right, and so the police say, we are arresting you for driving with a suspended license. They don't say, we're arresting you because we have probable cause based on a search warrant. So do we look at the reason that they stated for the arrest, or do we just, after the fact, support what they did by saying, well, there was probable cause, and so because it was objectively available to them, then even though it wasn't what they intended, we'll just say, hey, that's okay.
I believe looking at it objectively, there was probable cause.
Right,
which
but
would make
that's not what they
which-
said at the time. What they said at the time was that they arrested him for driving on a suspended license.
Correct,
So if we're
but
limited-
even,
So what I'm asking, is there a case that says, even if that's what was on their mind, we can disregard that and we can say, well, even though what they did was not correct, assuming it was not correct, it's okay because objectively they could have stopped him?
I'm not sure that I'm getting at your point, Your Honor, but the case that comes to my mind is the Commonwealth v. Wilkerson, 436 Mass 137. It's a 2002 case where an officer completed an arrest based on information from the RMV that later turned out to be erroneous. Not just whether it was known or not known, it turned out to be wrong. But the court upheld the arrest because it was a good faith basis. It's the information that the officer had. So I guess in following that line of logic, whether they said even if it turned out that they were completely wrong about the operating suspended sentence, suspended license, excuse me, they had an objective reason. They had the probable cause for that arrest, regardless of what they said.
Here we have an officer who testified that at the time he activated his emergency lights, the defendant pulled over on his own because his home alarm was going off. The officers pull in, they activate their lights. At that moment, right, the officer said he didn't know who was driving, so he didn't know the defendant was driving.
Correct.
So what's the basis for the seizure at that moment when they turn those lights on?
They still had probable cause for the controlled buys. So I guess the question.
Right, so that's why I'm asking, if the reason that they approached him at that moment, that they stated, was because he was driving on a suspended license.
But they also knew about the controlled buys, whether or not they said that to him or
They
not.
didn't say that. They've said, we arrested him because he was on a suspended license. So what I'm asking is, do we then just say, well, even though what they did was not accurate, we're going to say it's okay based on the objective availability of probable cause? I'm just asking for a case.
I can't point to a case off the top of my head, Your Honor.
Wasn't there testimony that the defendant was driving the car when they initially pulled up to the building?
Yes, there was testimony from a detective that was at the complex.
Keating, right?
Yes, Detective Keating saw the defendant drive in, park in a space that he had seen him park in before with the green vehicle, now with a white vehicle, saw him park. And then my recollection of the testimony is that Detective Keating went back to the station and relayed information to other detectives that were later at the condominium, and then saw the defendant and two individuals, as had been described by Detective Keating, going into the home, come out of the home, get into that same vehicle, and drive away.
So the reason I asked is OAS arrestable only in the moment? In other words, if the Commonwealth were seeking to rely on the fact that the defendant had driven the car to the building, would that support the later arrest? Or is you miss your moment if you don't get him in the driver's seat?
Well, I guess that would depend on if they had walked up to the vehicle and he was not in the driver's seat, but he was.
But they had already seized the car.
Is it a felony?
No,
Okay, it's a misdemeanor.
correct.
So I thought the rule was you have to see the person commit the crime, but it could be that they saw the previous crime.
Correct. But the argument could be made that if you've seen the vehicle leave, you've seen it pull over, you've walked up to it, presumably the individual that's in the driver's seat has been in the driver's seat. If there's no indication that anyone has swapped seats, then presumably they were the driver.
Well, they got out, they went in the apartment, and they came back, so all bets are off as to who's getting in the driver's seat. I mean, unless you know who owns the car, then maybe they're not, but they didn't say that they knew he owned the car. In fact, everything about a car was about a Camry, and this was a Corolla, and they're definitely different cars.
Correct, but I meant when the detectives saw the individuals come out and get into the vehicle and drive away, there was no testimony indication that they didn't see it for a period of time, they followed it.
Said he didn't know who was in the driver's seat.
Correct.
And he was observing the car the whole time.
Correct.
So, and it's your burden of proof.
It is.
So where's the proof that they knew at the time of the lights going on that they knew the defendant was the driver?
They testified that they weren't sure.
Right.
There isn't that proof.
Right. So then that's the question. Can they then use the earlier fact that someone did see him driving, but they didn't do anything at that time, they didn't act, they waited? Do you have a case that says that they're still okay to go and approach the vehicle with the lights activated?
Not specific to the OAS. I think the thought process was that it was still okay because they had probable cause in the controlled buys.
Right, and it would be lovely if they articulated that, but they didn't. They said they arrested him because he was operating suspended. That's it.
Okay, I think we're going to have to leave it there. Thank you very much.
Thank you.
We've been helped by both of your arguments, and the case is submitted. The
Thank you.
next case is 2020 P0593, Commonwealth versus James Bellard. Attorney Osborne, we're ready whenever you are.
Good morning, Your Honors. My name is David Osborne, and I am counsel for James Bellard. This case is, I think, will be quite a bit simpler than the previous case. It's a simple sufficiency of the evidence claim.
Sorry, could you just keep your voice up a little,
I'm
please? I'm
sorry.
having some trouble.
Sure.
Thank you.
It's a very straightforward sufficiency of the evidence claim. Mr. Bellard was convicted on the bribery theory of intimidating a witness under Section 13B, based on, almost entirely, in fact, on two back-to-back phone calls that he had with a woman we believe was Tasha Baskin, his fiancée.
So, counsel, you say the conviction was on the bribery theory, but the Commonwealth seems to argue, no, the statute's much broader than that, and it can just be some sort of interference or attempt to influence the witness's testimony.
That's not my recollection, Your Honor. They certainly did argue this as an intimidation case, as a bribery case. If you look at the closing argument of the counsel, of the prosecutor, what the prosecutor says is that there was an offer, there was a promise of support. I can tell you exactly what
What I saw
she
was when, I think it was the motion for directed verdict. Defense counsel made an argument that there was insufficient evidence of this, offer of anything of value. And the judge said, well, I'm not sure what the theory is. All theories are open in this complaint. I'm not aware of any limitation or bill of particulars on it. The only reason I mention that is I think it's distinguishable from Ruano on that basis. So, and then it's true, closing arguments are made, though based on that one theory. And then the judge, when explaining his verdict, actually does say that he's finding that the Commonwealth has proven that he made, under the statute, a gift, well, beyond a reasonable doubt, offer or promise of something in value. And references the marriage proposal, but also says it's based on other things he heard in the phone call as well.
Yeah, I think
so
the
let's
judge's-
assume
Oh, I'm sorry.
that the judge rested the conviction on only that theory.
Well, the judge did rest, certainly, I think there's no dispute that the judge rested her ruling on that
Sorry,
theory.
her.
But I also would point the court to the prosecutor's closing argument, where there's no evidence cited except evidence that theoretically went to the bribery theory of Section 13B.
All right, so I don't think, I think it's not just bribery, it's gift, offer, or promise of something of value.
Oh, I'm sorry, Your Honor. Maybe I'm not making myself clear. When I say bribery, that entire string of words
Okay.
constitutes bribery. We
All
have
right,
an analysis in
so
our brief for
we
that.
would agree that it doesn't necessarily entail the promise of cash.
That's correct.
We also can agree that a person can commit the crime even if they don't, in fact, have the capability of carrying out the offer. So I'm thinking of a case as the following, such as the following. A person says, look, if you don't testify, I'll pay you $1,000. The person doesn't actually have $1,000 or the means to procure $1,000. They could nonetheless have violated the statute, correct?
Absolutely, Your Honor.
All right.
Absolutely. I can see that.
So, so I think your argument that there's no way the defendant could have actually prevented officials from continuing to bother the victim isn't correct, because I don't think the capacity to be able to carry out the promise.
But it doesn't turn on capacity, Your Honor. The issue turns on what did he offer?
He offered,
what was he
he offered to make her problems go away if she didn't show up to testify against him.
Your Honor, there has to be, when I say bribery, I'm using that, this is the language, not my language, this is the language of the courts of the Commonwealth, which have said this clause, the offer of a gift or other offer, a gift offer or promise, that all constitutes bribery. And my argument is there has to be a quid pro quo. That's what bribery requires.
The quid here is don't show up and testify against me. That's been satisfied, right?
I think that you can construe that, yes.
Right.
But the important point...
then we're really focusing on what's he offering.
Exactly, because the important thing, Your Honor, and this is what the Ruano case talks about, it's one thing to have the intent to interfere to influence or to interfere with a criminal prosecution, but you have to have the prohibited act. You can't just have one. You have to have both. You have to have the intent to influence, and in Ruano, the court found that. They said there's a reasonable basis for concluding that the defendant had the intent to influence. But the reason the court reversed was because in that case it did not find sufficient evidence that he made he made an intimidating comment. It's not the same theory, but the concept is the same. You have to have intent linked with the prohibited act.
Right, so in this case, we're going to take the evidence in the light most favorable to the Commonwealth.
Understand.
The victim says that really the most important thing to her is to make her problems go away, her problems with DCF and with people coming to the house over this case, officials coming to this house. I don't know that she's even really clear who it is, but she says, you know, they're coming to my house.
Right.
I need all of this to stop. That's what she identifies as her problem.
That's
And
correct.
he says, if you don't testify, I can make that go away.
He doesn't say, I can
He
make that
says-
go away, Your
okay,
Honor.
what does he
It's
say?
confusing. I agree, this is not a clean transcript.
But the
It's a
judge
very-
can infer, right? The
Well,
judge
he's
can
what he
make-
says.
The judge
I'm
can
sorry.
make reasonable inferences.
But what he said, but we have to look at his words. This is
Sure.
what the whole Commonwealth's case depends on. This is the only evidence they have. It's just this transcript. So we have to pay close attention to the transcript and his exact words. And his exact words, at no point does he promise her any sort of support at all. He never promises to take care of her children, which the Commonwealth suggests is implicit, but it's actually not. It's a mischaracterization of the transcript. It was actually Ms. Baskin who talked about him taking care of the children. He never promises to house her, to loan her a car, to do anything. Whether he could have done it or not, there's no promise there. The only thing Mr. Bellard does, and I think you do have to step back and look at the transcript and try to understand what's really going on here. What's going on here is they're having one of their regular calls, apparently one of their regular calls. It starts off very chit-chatty and very gossipy, and periodically during this call, Ms. Baskin is complaining about feeling harassed, feeling very frustrated, feeling like she might lose her housing because the police are coming to the door, she's getting all these papers. And Mr. Bellard repeatedly responds by saying, just don't answer the door. Just don't answer the door. Just ignore it. It'll be over on August 2nd. That's when I'm back in court. It'll be over August 2nd, and then it'll stop. That's not a promise of something. He's just saying what's obvious, which is, you could call it advice, but it's not the promise of something of value. It's just a statement of reality. If you don't answer the door, it's going to end on August 2nd. What's really interesting in this case, Your Honor, which shows you how thin this case is, how remarkably thin it is that the trial did not happen on August 2nd. It actually happened in February of the following year. Presumably, these phone calls are happening all the time because they're in this relationship, they're engaged. This is the only phone call that the Commonwealth produced as evidence that Mr. Bellard was attempting to intimidate or influence this witness's testimony.
She
It's the
didn't
only
testify,
one.
did she?
I don't think that's in the record, Your Honor. He was acquitted, so we can construe whatever we can from that, but I don't believe.
I mean, on the underlying charge, he was acquitted.
On the underlying charge, the domestic abuse charge, he was acquitted. But that was in February. And so between July of 2016, when this telephone conversation, or the two back-to-back conversations take place, and February of 2017, there's not a single other incident of Mr. Bellard attempting to persuade her not to show up.
Well, right, but
offering
one is enough.
something.
We don't, I mean, it doesn't have to be in every
That's
phone
true, Your Honor,
call.
but I think you have to give a degree of scrutiny to this transcript, given that this does not appear to be some intended plan by
Right,
Mr.
so
Bellard. It's
the
just a
Commonwealth
conversation.
expressly argues that he was attempting to convict the only adult witness of the assault and battery not to appear at the criminal proceeding against him, and that interfered with the administration of justice. I take it,
Pardon me, Your
you
Honor.
think that is not a crime?
I didn't catch the first part of what you said.
The
I'm sorry.
Commonwealth is expressly arguing that he was attempting to get the only adult witness against him on the assault and battery to not testify, and that was, quote, interfering with the administration of justice, and that was sufficient for a
Enough.
conviction. It's not
It's
enough.
not enough, Your Honor.
So what
It has
more
to
is
be-
needed?
It has to be, well, that's the intent, right? That's what we just talked about. That's Ruano. That's the intent. the Commonwealth also has to show that he attempted to do that. It could have been unsuccessful. It could have been something he couldn't have carried out, but it has to be through a threat, coercion, or it has to be through some act of bribery, which is the offer of a gift, a promise.
So you're saying that if he just told her what would happen if she just didn't answer the door, that that's just a statement of fact?
It's not a crime, Your Honors. I understand, perhaps it should be. Perhaps the legislature should make that a crime. But the legislature instead has said that there are very specific things the Commonwealth must prove in addition to intent, because it is a specific intent
So
crime.
if, some of these children are also his children, correct?
I don't know, Your Honor, and certainly it's not reflected in the record. It's ambiguous on that point.
Okay. So if he's saying if I'm out, I will do what I was doing,
Yep.
is that enough
No.
to be something of value?
No, I feel strongly about this case, I'm sorry. No, it's not. Because we have no idea what he's talking about. And remember, we have to, when you're making these inferences, certainly a court can make an inference about whether something is based on facts. You can infer something. But if there are two equally plausible inferences, you can't pick one over the other. You have to, that's not sufficient for Lattimore purposes. One has to outweigh the other. And in a case like this, I think, if he says something incredibly ambiguous, like, well, I got to get out of here, and then I'll be out, we have no idea what that means.
He says, babe, you won't be going through this shit if I was out there with you. That's what I'm trying to say. I need to get out there, she says, how won't I be going through it? He says, because I'll be out there with you.
Right.
We
And the
don't need
shit-
to worry about. And what he's referring to is everything she just described to him about DA's offices, DCF,
That's
all
exactly
of her problems. And he tells her, if you don't show up, because there's later at my trial, I'll be out there with you, and then you won't have to deal with those problems.
Well,
How is that not quid pro quo?
No, Your Honor, it's not. What he's saying is, on August 2nd, this case is, you don't cooperate, you don't answer the door,
Don't
you
show
just
up.
ignore it.
He tells her at one point, don't
Yeah.
come to the trial.
Just-
I'm going to tell you, this is how it works. You need to trust your man. I know because everybody in here I'm sitting in here with a bunch of blanks in the same predicament. And don't show up.
But that's not an offer. That's not an offer. That's not a promise. That's
And
not a
the
gift.
reason, and what he gives her is the reason for her to follow his instruction. Why couldn't the judge conclude that the reason he's giving her for why she should follow his instruction is that he will then be able to protect her from what she's worried about if he's out?
He never says that. It's not. She doesn't want to be protected from it after he's out, because what he's saying is that's going to end when I'm out, when the case is over. That is not an offer, a promise, a bribe. That is just a statement of reality. When this case is over, this will stop.
He's incarcerated, she's out. Assuming he gets acquitted of the underlying charge, there's no guarantee he's staying with her. And so isn't he saying, if this goes away, I'm going to stay with you and provide whatever level of support I was providing before?
Not the transcript I read, Your Honor. He never says anything of the sort. He says that I need to be, at one point he says he needs to be out there, but he doesn't say it in the context of this. He talks about it later. It's completely divorced from this concept that he'll be out there. The Commonwealth says in the trial, the prosecutor argued, well, he said she won't be alone. He said he needs to be out there so that she won't be alone. That never happened. You cannot point to language in this transcript where he ever says, you won't be alone if I'm out there.
Well, he says on page 19, lines 20 through 22, babe, you won't be going through this shit if I was out there with you.
Right, because
And he says, because I'll
case-
be out there with you.
Because the case is over and he's out, he's free. I mean,
All right.
you can, as I said, you can infer that perhaps.
Well,
but-
I think we need to leave it there.
Can I just follow up with one question? Sorry. I mean, I've been trying to come up with the right analogy to help me understand how to think
I know.
about this case, and I've failed. But, so.
I tried to, Your Honor, very hard.
But he does, sort of woven throughout these two conversations is that his lawyer has told him this. And so,
He said it once, he said that once, yes.
all right, we can disagree. I thought I heard it, I read it a couple
I think there
times,
was
but
only,
I'm
the
sure you've
transcript
read
is what
this
it
more
is,
than
but
I
I think
have.
at one
So,
point near the end, he did
all
say
right,
that.
let's
in the
say
second
once.
conversation.
Doesn't that change the nature of the information he's giving her because there is an aspect of, I don't know, like specialization or extra professional knowledge or something to what he's telling her? In other words, that it's not just by operation of fact. It's not like, this is the best analogy I could come up with, which stinks. It's not just that I tell someone who's about to go drive on the turnpike, if you stay under 55, you won't
Yeah.
get pulled over for speeding.
I mean, it's interesting, Your Honor, because at another point, Mr. Bellard actually does say, look, it's your call. You do what you want.
He does.
So, this stuff cuts both ways. And to me, when I read this very messy transcript, kind of ugly, very messy, and it's happening when she's on a bus and there's a lot of yelling, they don't understand each other, and sometimes you just can't understand the vernacular. But when I read this, I just read a man who's dealing with a fiance who's upset, distraught, and he's saying whatever he has to say to kind of calm the situation down. But you can't detach that from the intent to influence. Obviously, he's got this interest in her not testifying. But when he's saying that stuff, is he saying it because he needs to say that in order to keep her from testifying, and this is going to do it? Or is he saying it because he's trying to calm her down? And that's where I say, when there's two equally plausible inferences that you can draw from the evidence, you can't pick one over the other. The evidence is insufficient as a matter of law. And that's, I think you can go both ways, Your Honor, just as you point out. But then if you're going to look at that, you've also got to look at where he says, do whatever you want. Do what's right for you. And that, to me, tells me he's just trying to calm somebody who's upset. He wants to talk about other things.
At this point, I think we've heard all of this, and you're over your time. Thank you very much.
Good morning. May it please the court, Kristen Jang for the Commonwealth. In this case, the Commonwealth presented sufficient evidence that the defendant promised something of value to the victim in an attempt to influence her not to cooperate with a pending prosecution against him. And that promise, as Justice Wolohojian pretty simply put it, is that if you do what I say, all of your problems that you've been talking about this entire day, all of your problems will go away. And it's clear throughout the transcript that that is extremely valuable to the recipient here.
Well, let's get to the transcript. I mean, basically, the defendant is arguing that you have attributed a statement by Ms. Baskin to the defendant and thereby created an incorrect impression from the transcript. So what do you say to that?
Oh, I apologize if I've caused any confusion. I don't believe that I attributed that statement that I believe it was, I do agree that it was Ms. Baskin that said at one point, you know, you help me with the kids. But what I was doing in my brief was taking the entire conversation as a whole, marshaling all inferences in favor of the Commonwealth, and tying that to the defendant's statements that he wants to get out there with you and do what I was doing before. So I was using that statement to provide a little bit of context as to perhaps what he was talking about. I'm going to do what I was doing before. And that was the purpose for me pointing that piece of the transcript out. And I apologize if it made it sound like it was the defendant who said that, because I agree that he did not say that, you know, I'm going to come out there and help you with the kids. I do agree that that's not in the transcript.
So,
Sorry, go ahead.
well, if the judge was wrong about the defendant offering to marry the victim during the call, why can we still affirm?
So I cited a case, and I don't remember the name of it off the top of my head, but I think what's very important here is if you look at the transcript, she says, for all of the reasons I just heard on that recording, and because I heard an offer of marriage. So she's basing her decision on both of those things. So, and I cite a case that said, as long as there's other sufficient evidence outside of the fact that was clearly erroneous, the conviction can still be upheld.
Whereas here, there's a bench trial, and the judge states the theory on which the judge is resting the conviction. But the conviction could rest on other theories. Doesn't seem to be the theory that was pressed at trial, for example, threats. And the judge articulated a different, adopted the Commonwealth's theory for the conviction. Are we able to look at alternate theories for the conviction?
I think under Rwano, you are not. So in that case, the court actually found that there was sufficient evidence of a promise of something of value, but that is not the box that the jury checked off. In that case, it was a jury trial. So for that reason, that conviction was not upheld. So here, I think for the same...
we just couldn't look to see whether we thought the conviction also could rest on threats.
Correct. I really don't think that there was evidence of that in any case, but no, I don't think so. I think under Rwano, you're kind of stuck with whatever the judge whatever theory the judge adopted.
So do we know if any of these children were his children that he had an obligation to support?
I do not know. That is not in the record of either case.
Let's assume for the minute that they are, if in fact a parent is offering to do what they're supposed to do anyway, is that something of value?
Sure. I mean, he's saying he wants to get out, presumably that, you can infer he's going to get a job and he's going to, your support obligations are pretty low if you're incarcerated. It would be the minimum.
Let me put it a different way. Is the question of something of value an objective test or a subjective test?
I believe under the Hayes case, it's a very old case from the 20s, you do look at subjective intent, and that's cited over and over again in the case law. That a key consideration, that was a bribery case, but this is pretty similar. The key consideration is whether the offer was valuable to the person who was solicited. And I also cite the case Vasquez, where the use of a Jaguar by a corrections officer, I believe, was valuable to that person, maybe not to the average person, not to me certainly, but you would look at whoever the person is being solicited and what is valuable to them.
So assuming for the moment that he did hit her, on whether it's a frequent or infrequent basis, objectively, many people would say that getting him back is not of value. But you're saying that but looking at the whole package, it can be of value to her because he provides some other benefit.
Well, she talked again and again about what she wants. She just wants all of this to go away. She wants to make sure her kids are going to stay with her. She wants to make sure she keeps her housing. So explicitly...
Right, but what he's saying is, what your opposing counsel is saying is that whether this all went away was essentially 100% in the victim's control, she could just decide not to cooperate. And he's just pointing that out as a factual matter, and where we've got two equal propositions, we can't just pick the one that favors the Commonwealth. So what's your response to that?
My response, I think what's really important is that he weaved in the advice from his lawyer, and that he made it pretty clear that his main defense was going to be that she's not going to show up, and he made it clear that he talked about that with his lawyer. And so I think what's key here is that he was telling her, I'm going to employ this strategy in making sure this goes away. All you have to do is do your part. And I'm happy to answer any more questions, but otherwise I will rest on my brief.
Questions? No, I don't see any. Thank you both.
Thank you very
Thank you
much.
both for your argument and your briefs, and the case is submitted. The next case is 2022 P0650, Commonwealth versus Vincent Mitchell. And I'll just note for those of you who might be interested that we're going to take a morning recess of about 10 to 15 minutes after this argument. Attorney Vizone, we're ready whenever you are.
Good morning. If it please the court, Joseph Vizone for Vincent Mitchell. This case has a lot of moving parts. at least in my mind. It's a constructive possession case, and so the question is, did Mr. Mitchell have the intent, the present intent, to exercise dominion and control over the drugs that were found in a room that, somebody left their glasses here, in a room that he had occupied at one point or another. There was a search of that room, and there was documentation in there. There were rent receipts. There was a receipt from Sprint, a number of receipts that had his name on it. But some of the addresses were 9 Falula Street, and some of
Right, so
the...
the Commonwealth says that the receipts with the other address seem to be wrapping up accounts there, and that the receipt for 9 Falula was to start things there, so that the inference is that he had moved in.
Well, I don't think you can go that far and say that it was a receipt wrapping up his prior phone bill. I think that just it would be supposition. I don't think there's enough there. I mean, there was other things there that showed that he was living at Rollstone Street, and there was so.
How about the TV?
The TV is interesting. It does have the name Vincent on it when you turn the set on, and that's not good. But you know, he could have left his TV behind, and now he's at Rollstone Street. I'm sorry?
Plugged in, working with Vincent on it?
I don't watch it, you know. And so that's.
Were the bills, was the paperwork introduced at trial?
You mean the receipts and?
For the exhibits?
Yeah, that's in the record.
So, I don't think we have those in the appendix.
In the appendix, there's some photographs of the drawer, which was opened up, and you can see.
Right.
There
I
are,
saw
but it's
that,
hard to see the
but you
papers in
can't
the
see-
photo.
So, but were the documents themselves entered as exhibits?
I believe they were.
So
they
the
were.
judge could have seen, like, the dates on those, and which we can't really know ourselves, and seen whether this theory that they were, you know, there might be a narrative there based on the timing, on the
But then
dates on those documents.
Right, but then I think you also run into how much of those documents would constitute hearsay? Can you take what's on those documents for the truth of the
But
matter?
were they admitted?
I'm sorry?
Were they admitted?
They were admitted just to show that, you know, where does this guy live? I mean, the argument was,
Right.
well, he's got receipts, whether they're Rollstone Street or whether they're Fallujah Street. He has these receipts where the search is being conducted, so therefore.
They could be admitted for the purpose of, that they were addressed to the
To him.
person they're addressed to at an address that they are.
Right, they could be admitted for his
On a
name is on
date-
it.
on a
and the-
date.
And the thing is actually found where he doesn't want it to be found. The other problem with the constructive possession is that he wasn't there at the time they executed the search warrant. He wasn't arrested until, I believe it was 6 days later at a local U-Haul place. And when they searched him at the U-Haul place, he didn't have anything on him that one could infer was part and parcel of the drug trade. No
When-
weapon.
Am I correct, but I don't know, that there was a confidential informant, or maybe two, involved in the case, but that no confidential informant information came in during the trial?
No confidential informant came in during the trial. They just used that to establish the buys and the cause to get the search warrant, which I'm going to get to.
So that was only in connection with the motion to suppress, that any of that information
Right.
was before the court?
Right.
So, so was there any testimony, not, these photographs or the bills, that tied the defendant, that at trial, was there any testimony saying that the defendant had participated in sales from that apartment?
No. That was just all
That was all part of
part and parcel of getting the warrant.
Okay.
Not in the case in chief. So again, everything that you have here is inferential, okay? And it depends, is it enough to establish probable cause to indict him? Yeah, I think it is. But guilt beyond a reasonable doubt and to a moral certainty, that's why I'm here. 'Cause
There
I don't think
was,
it is.
right, there was evidence at trial that the police had observed the defendant leaving that apartment on occasion and going back?
Yes, but was he just going there to buy for himself? Or, just seeing people come in and out, that's not enough to imply that he had an intent to distribute.
How about the fingerprints on the safe, though? I understand you make an argument about the APHIS
Right.
card. Assume for the moment that, just for the purpose of this question, that's, that you haven't convinced me that's hearsay.
Well, there's a temporal element to this too, because you have to be, you have to have the intent to possess and distribute at the relevant time period. Now, he probably lived at Falula Street at some point in time, and maybe at that point in time, he touched that safe for whatever reason and left his fingerprint, because there was evidence on cross-examination where I believe they asked the trooper, can you tell when a fingerprint was put on an object? And he says, no, you can't. It's either there or it's not there, but you can't say it was put on at a certain point in time. So we don't know when the fingerprint was put on. And getting back to your point, the other problem was that the police officer who took the original fingerprint was asked to identify the person that he took the print from, and he says, the gentleman in the purple shirt. Well, the gentleman in the purple shirt wasn't Mitchell. He was the co-defendant. And so, I don't think when you look at the fingerprints and say, okay, now the standard is beyond a reasonable doubt, I don't think you can get there. Again, you can get there to indict him,
Well, I think
indict a
the
ham
Commonwealth
sandwich, as they
is,
say, but you can't.
right, the
Beyond a reasonable doubt is a whole other kettle of fish.
The Commonwealth is going to say that the misidentification was tentative and the judge didn't have to accept it, and looking in the light most favorable to the Commonwealth, the judge could accept that the fingerprints were of your client and that there was testimony the fingerprints matched. Why is that not enough?
Well, I disagree. I mean, you have to lay a foundation to show that the thing is what you say it is. And if you have a police officer come in and say, the guy that I fingerprinted was this guy, and it's, no, you're saying it's this guy. You don't even have the right guy. If you have the police officer says, I fingerprinted the co-defendant, that to me, at least in my mind, is game over. You don't even have the right guy's fingerprints. If there's fingerprints there, and assuming everything else is okay, you have the
So if
fingerprints of
we-
somebody else.
If we accepted that argument, which we're reviewing under an unpreserved error standard, substantial risk, then we look to see whether that evidence should not have been admitted, the fingerprint evidence had not been admitted, and determine whether there's a substantial risk of a miscarriage of
Right,
justice.
it wasn't objected to at trial, so
Yeah,
whether
'cause
the
it
card
wasn't
comes in.
It wasn't objected to.
It was not, so it's substantial risk, absolutely. If I could get to the search warrant itself, again, you have a search warrant that's facially defective. I don't think anybody disagrees with that. And the question at the
When you say
most...
it's defective, you're saying because it didn't say they could look for paperwork tying your client to the apartment?
Right, right.
Okay,
Right.
but the
He had Mr. Jones's name on it,
It
but
did.
not
But the
Mr.
Commonwealth argues that, and relies on Commonwealth versus Demore to say that these documents would have been discovered inevitably because they were allowed to look at paperwork, and they would have seen the paperwork that mentioned the defendant's name. So what do you say to that?
Well, what I say to that is that the purpose, and again, I quoted Commonwealth versus Valerio, the purpose of having the warrant physically at the scene, and in the affidavit as well, if the warrant is facially defective, excuse me, all of that is to protect the constitutional rights of the person who's being searched, okay? And the doctrine of inevitable discovery doesn't protect anybody. If anything, it provides an out for the Commonwealth. because they can get something in which they normally couldn't. This is a warrant case. And the case law, the federal case law that I also cited, says that you have to have that warrant present so that the person who's being searched can pick up that warrant and say, hey, wait a minute, this warrant says you can search over here, but it doesn't say nothing about searching over there, and you're going over there.
No issue about searching this place or that place. What they're saying is they were looking for paperwork. They were permitted to look at paperwork because they could look at paperwork for somebody else. And so while they were doing that, they inevitably found this paperwork. They weren't in a room they weren't supposed to be in. They were allowed to be in the bedroom.
That's correct, but the point is that the warrant has to be present as an added layer of protection to an individual's
I thought
Fourth
you were
Amendment protection.
challenging whether the search warrant affidavit was present, not whether the warrant was present.
Well, as I said in my brief, based on the motion to suppress transcript of 1218, there was not a shred of evidence in there that I could see where either one was ever physically present at the apartment that was being searched. In fact, when the prosecutor...
But did you raise that issue below? Did your client? Because if you don't tell the Commonwealth, oh, it has to prove it's certain parts of its case, then then often it doesn't, and we don't say gotcha later.
Well, the question at the suppression hearing was it a defective warrant globally? And yes, it was a defective warrant for two reasons. One, it was facially defective. The Commonwealth says, yeah, but we have the affidavit, and the affidavit cures the facial defectiveness.
Wait a minute, I want to stop you
Yes,
there.
yes.
I don't see how the fact that something's not included in the description of things that can be searched for makes the warrant defective. There's no defect in the warrant. You're just saying the warrant didn't extend to a search for documents relating to the occupancy of Mr. Mitchell. That doesn't
Correct.
mean that the
And that-
search warrant is defective.
Right, because they're allowed to...
Okay, so it seems to me they're there pursuant to a valid warrant. And you're saying that what they did was exceed the scope
Right,
of the warrant.
right.
Not that the warrant's defective.
They exceeded the scope,
They exceeded the
absolutely.
scope. All right, so they
We
are,
agree on
as
that.
Judge Henry said, they are where they're allowed to be pursuant to the warrant.
Right.
When they see these documents, which apparently are in plain view. Why does the plain view doctrine not permit them to look at documents when the police are where they are authorized to be pursuant to the warrant?
Well, because under Valerio, even if you had as we agree, it's a good warrant, okay? Even if you have a good warrant, all good warrants have to be physically present where you search. And if it's not, there's a problem.
But here, I believe the evidence was that maybe the affidavit was not present, but there was evidence that the warrant was present.
Well, see, that's where I disagree. My reading of the transcript was there was no testimony from, I believe it was Trooper Dolan, whose affidavit it was. He never testified that I physically brought this warrant, not the application, because the prosecutor says, what am I showing you? And he said, an application for a search warrant. Well, an experienced state trooper knows the difference between an application and the actual search warrant, okay? And so he wasn't shown, okay? And there was no testimony that said, when we executed the search at Falula Street, the warrant and the affidavit were physically present as they were in the Valerio case. So that's why I say the doctrine of inevitable discovery doesn't make it.
Did the defendant object at that point or at any point during the hearing that the warrant itself was not introduced?
At the suppression hearing?
Yes.
I don't believe so, no. There was the only witness that testified, excuse me, at that hearing was Trooper Dolan, and I don't recall.
I take it when you say there were two defects with the warrant, one was that it exceeded the scope, and the other was
Yes.
that they didn't prove at the hearing that the search warrant was present?
That the search warrant was not physically present at the place to be searched, which my understanding the case law mandates. And if that doesn't happen, if it's not physically present, then all the exceptions to the hearsay rule are of no avail.
The affidavit in support of the application for a warrant is normally stapled to the application for a warrant, correct? It's normally attached to it.
Yes, right, and then they issue the
All
warrant.
right, so here, when the trooper says he's identifying the application, why would we not assume that the affidavit was attached to the application?
Even if it was, the point is, it doesn't matter if it's attached, you've got to have evidence that all of this stuff was physically at the scene.
Right, but he
And we don't have
testified
that.
didn't he testify that the application was present?
The case law doesn't make any mention about applications. The case law says the affidavit has to be physically present so that the person being searched, knows what they can search and what. You don't want general warrants, okay?
Okay.
And if it happens to be defective, then we want you to have the affidavit also physically present, again, so that you can apprise the defendant of what these guys can search and what they can't. So
All right, let me
I
see
think
if
I'm
there-
up.
Let me see if there are any further questions. No?
Yeah, just, the Commonwealth's arguing that there was some confusion where the chemist was using report interchangeably with the certificate, and that you have everything, or the defendant had everything. What do you say to that?
I missed.
The Commonwealth is saying that on the issue about discovery from the chemist, that you have everything, that she was using the word report and certificate interchangeably.
Who's using them interchangeably, and I don't, and the rule 14 says documents of any sort, so it's every kind of document that was used in any way to formulate this opinion that this substance was or was not heroin or cocaine, as the case may be.
Okay, I think we'll have to leave it there. Thank
Yes,
you.
thank you.
Attorney Kennedy? Someone left their eyeglasses?
Not me,
Okay.
somebody before.
Ann Kennedy, Assistant District Attorney for the District Attorney's Office for the Middle District. Good morning, Your Honors. I wanted to address a couple points that were asked in my brother counsel's argument. First of all, his record appendix doesn't contain the documents, but the Commonwealth's supplemental appendix does, that you were referencing, and I believe they're at page 47, 48 with respect to the Comcast and the Sprint bill. Additionally, also contained in the Commonwealth's appendix is the document that was, the photograph of the employment application for Vincent Mitchell that was found in the Bureau, in which and upon which all the a lot of the drug paraphernalia and drugs were found. So I just wanted to bring those points out. At this point, I would like to start by saying that the defendant's convictions in this case should be affirmed because the motion judge correctly denied the defendant's motion to suppress, and then the trial judge did not abuse his discretion in the several evidentiary rulings that defendant is now claiming should not have occurred, as well as in denying the defendant's motion for a required finding of not guilty. I think it's...
Sorry, can I just pause you on the warrant
Certainly.
for a moment? What is the factual basis that the Commonwealth asserts supports the motion judge's finding that the affidavit was accompanied the warrant at the scene?
Certainly, Your Honor. The factual basis is a combination of the testimony plus the exhibit as it was introduced into evidence. You have Trooper Dolan, who authored the affidavit as well as the application for the search warrant and executed the search warrant the next day, testify as such. You have the prosecutor introduce as an exhibit the application, the warrant, the return, and the affidavit.
How do we know that that's everything that was introduced?
Well, Brother Counsel provides that exhibit in his appendix as Exhibit 1.
And you're saying that has all of those pages?
It should, yes. I believe it does. If not, I know I incorporated some of that in mine.
Well, I know I have those things, but I don't, can you give me the pages? Because I didn't see anything that showed it was the actual exhibit.
I believe the first page of the record appendix for my brother, that my brother submitted, says Exhibit 1. I apologize if I'm
It's a
off on
PDF
that.
50 of his exhibits, of his record appendix.
Yes, his record appendix is 50 pages. I believe it's the first page. That's, I could be.
I see, because if you look at the table of contents.
Right, but the question or the
oh.
problem we have is if you look at Exhibit 1, which is at PDF pages 50 and 51, it's the search warrant and the application, but the affidavit is not attached.
And what I did is I incorporated the affidavit as well as the warrant in my appendix. That was
But how
attached.
do we know what Exhibit 1 was?
We don't have anything reproduced in the appendix that has a sticker on it that says
Oh,
Exhibit 1.
I thought page,
Page 50
50
does, but
does.
how do we know that Exhibit 1 is more than pages 50 and 51?
I understand, I apologize, now I understand what you're asking. At this point, the Commonwealth can provide that supplementally. That is the exhibit that was submitted at the motion hearing. I
To
actually,
me, the two of you need to cooperate and try to get a copy of the original if you can. 'Cause that
Certainly.
will straighten out a lot of
certainly.
things pertaining to this argument.
My brother doesn't deny that those things were introduced, that those things were submitted as part of the exhibit. What he's claiming is that it was a mistake on the clerk's part to call them an exhibit together, that it was a mistake on the clerk's part to submit the warrant with the application, with the affidavit.
Well, but that's exactly the problem, though. If the trooper says this is the application, right, and it wasn't, and nobody corrects him, how do we know? We have.
Certainly.
So we're sort of stuck.
Certainly. The other piece, and we will discuss that, but the other piece of information with respect to that at the hearing as well, when the prosecutor references the exhibit again at pages 13 and 14, he's having the trooper talk about he's asking the trooper questions about the return as well as the warrant. Just so you know, if the entire context, but we will clarify that and we will get that sent to this court.
Okay. I mean, I do think it's important to underscore that every transcript needs to be crystal clear about what the exhibit is.
No question.
Okay.
No question, Your Honor.
And then,
Go ahead.
So,
I just want to take the next step on that. I appreciate that we'll be able to figure out what Exhibit 1 was, but obviously the fact that papers were stapled together and made into one exhibit doesn't get you to the next question, which is what papers, if any, were at the scene. And the only piece of Trooper Dolan's testimony that I've been able to identify that seems vaguely relevant to that, but I'm looking for help, is on the top of page 11 of the motion to suppress transcript, where Trooper Dolan's asked what his role was during the search, and he says, I was the case officer, so I was marking any evidence collected, writing down who was in the house when the search warrant was executed, and just documenting everything that was happening throughout the search. End of answer. There's no part of that that says, and I was doing that on the return, I had the warrant and the application and the affidavit with me. You know, it's not like whatever the case is that I can't remember the name, where the guy testifies about the Rubbermaid with the stuff in it. So how do you get from that piece of testimony to it was all at the scene?
first of all, and maybe I've misunderstood it, I haven't understood my brother's brief as arguing that the warrant wasn't present, that it was just that the affidavit wasn't present at the scene. Additionally, below, the issue, I think Justice Henry asked, what was the issue that was raised at the motion to suppress hearing? And it was whether or not the retrieval of the documents and certain other things went beyond the scope of the warrant. So the issue at trial was not whether the search, at the motion to suppress, was not whether the search warrant was present. The issue was whether the affidavit was present and whether or not the police exceeded the scope.
Right, I don't
So-
disagree with you about the argument. I guess what I was inelegantly trying to ask is, I think, the argument seems to have proceeded as if there's evidence that the warrant itself was at the scene, but the only question is whether the affidavit was attached. I don't even see anything supporting the assertion that the warrant itself was at the scene. I understand ordinarily it would have been, but that's different from proof.
Absolutely, Your Honor. But again, because that wasn't a piece that was being questioned by counsel, we were not required to meet that burden. But with respect to the presence of the affidavit at the scene, if that's the information that can connect all that, is that the trooper was the one who testified, that he was the one who wrote the affidavit, that he was present at the time of the warrant's execution, and that the warrant was introduced, that all of that was introduced as one exhibit. That combined would give the judge a reason to believe that the affidavit was present. The question is whether or not that this court has to address is whether or not his finding was clearly erroneous. And the question for this court to address that, this court has to find that there was no evidence that the affidavit was present, or that you are left with the definite and firm conviction that a mistake was made. And if you apply that standard, it's reasonable to assume that the affidavit was present, as that is what the judge found.
But you're chasing your own tail on that, right? Because I'm asking you, well, the judge, I mean, if we're trying to figure out if the judge was, reasonably assessing the evidence, the question is, well, what was the evidence? Which is a question I asked you, and I don't think you've pointed me to any additional pieces.
I have not.
Okay.
I have told you what the evidence that was present at the hearing was, is that the trooper who testified was present, and he's the one who wrote the affidavit. There's no direct testimony that the affidavit was present at the time that the warrant was executed.
So why can a judge reason their way to the fact that the affidavit was present? I mean, it was or it wasn't. There's testimony, there's not. It's not like there was no snow on the ground last night when I went to bed, and now there's snow on the ground, so I can infer snow fell. Like, we have no idea. You're just kind of making it up if you say that the affidavit was there.
Well, there's no testimony either way. This isn't a situation where he said the testimony wasn't, the affidavit wasn't present. Would I have appreciated if the question was asked, was the affidavit was present? Yes. Would I be before this court arguing this case right now? Probably not with respect to this. But the question becomes is whether the judge's finding was clearly erroneous.
What is the relief if the warrant isn't present?
You mean the warrant or the
Warrant.
affidavit?
The warrant.
If I could, Your Honor, with respect to, before we get to that, with respect to whether or not the warrant was present, again, that wasn't an issue.
I know, I'm just asking for some legal education here. In a case where the warrant isn't present, what's the relief?
Then you don't meet the particularity requirement, and because you don't have the warrant, it would be like executing a general warrant, I would imagine. And so if the warrant was not present, then the evidence should be suppressed.
If there's a warrant and there's no affidavit present, if there's a warrant present but no affidavit present, just accept those as facts. I realize
Certainly.
that's disputed. What's the relief?
The relief at that point depends. The relief depends upon whether the search exceeds the scope of the warrant. And the affidavit doesn't have to be present, and oftentimes the affidavit and the warrant are in conjunction with what's supposed to be searched for and where it's supposed to be searched. That didn't happen in this case. So if the question is whether or not it exceeds the scope of the warrant. And with respect to this case, as the Commonwealth has argued, the items were found in plain view.
So if my colleagues are done on that topic, I wanted to turn to the fingerprints where we have this problem where the police officer said, I took that guy's fingerprints and that guy was not the defendant that you say matches the fingerprints.
Well,
How do we?
How do you get around, how do
Yeah,
I
we
get around that? Well, first of all, what it is that if the testimony was that specific and that, I'm escaping a word. In this situation, it was very clear that even from the cold transcript, that the witness was unsure as to who he was identifying. He had indicated that he had made the arrest 6 years prior. He indicated that he wasn't sure, and he indicated at the end, even the second time, it's been a while, but I believe it's that person. So that inability...
Even if it's a tentative misidentification, it's not an identification of the defendant.
No, it is not.
So, so in the absence of that, how have you got a foundation, or how have you got proof that the fingerprints on the card, the AFIS card, belong to the defendant?
That's where I would refer you to the Wolohojian case. I'm not sure if I'm pronouncing that correctly. In that particular case, they said that you can assume that an arrestee, upon arrest, gives the correct identifying demographic information, that assumption can be made. And that's how Wolohojian enabled the authentication of the fingerprint documents. So based upon that, based upon the fact that that person identified themselves as Vincent Mitchell, and we cannot escape the fact that
Okay,
those
so-
prints were found in the house that Vincent Mitchell was in.
So, yes, were there any, did anyone say that he was fingerprinted for this arrest and his prints were there, or was it all tied to the fingerprints from 6 years ago from whoever that person was?
It was tied to the fingerprints from 6 years ago. That was the AFIS printout was,
And that's the printout that does not bear his signature?
no, it is not a signature printout, it's a digital copy.
Right, but there was nothing to indicate his signature.
His signature, no. But what happened is at that time, the way the Fitchburg Police Department was computing fingerprints is they were doing it on the computer. They were not doing the ink prints. And the
Oh,
copy...
yes, but for better or for worse, we all sign these electronic things where our signatures don't look like our signatures, but at least it's a signature that we
Yes.
signed.
And there was no signature on it.
There was no signature.
No.
And so, and you're saying that under Fulgham, the SJC has said that we can trust an alleged criminal to,
You can make that
Not lie.
assumption, yes,
okay.
yes. You can make that assumption.
Can you make that
Again,
assumption when the police officer has said it's the guy in the purple shirt and it wasn't the guy in the purple shirt?
I guess that's what, I think the question is whether when viewed in a light most favorable to the Commonwealth, the judge could make that conclusion. And we have to remember that to look through this of the lens of the bench trial that this was not a jury trial. And I think if you look at it through that lens, given what the judge could and could not have found, he could have made that determination.
Let me see if there are any further questions. No. All right. With that, we're going to have to leave it there because your time has expired. Thank you both for your arguments. It's an interesting case, and we've been helped by your briefing and your arguments.
Thank you, Your
The case
Honors.
is submitted. The case is submitted, and we're going to take our morning recess. We will return within 15 minutes.
Good to see you again.
Perfect. Excellent. Thank you very much. You do, yeah. I'm terribly young. So you know about it, but watching the live stream now that you're all famous on the internet, he said, "Go upstairs and see if you can grab it." Okay, thank you.
seated.
Okay, welcome back. Our next case is 2022 P0234, BERXHIKU versus, ALTIN BERXHIKU versus Brendan Gonzalez. I hope I pronounced
Close enough.
one of those names correctly. All right, and is it Attorney Comenzo?
It is.
We're ready whenever you are.
Thank you very much, Madam Justice. Good morning. May it please this panel, my name is Joseph Comenzo. I'm here on behalf of the appellant, ALTIN BERXHIKU. We are here to request this court essentially reverse a finding of fact of the Massachusetts Land Court and as a result enforce a judgment on behalf of the appellant. I'm happy to, I believe that the issues were pretty adequately briefed in my memo.
Yeah, so it looks like the judge is looking at this 1998 exhibit and saying it could be a fence or it might not be a fence, and that's not enough.
Correct, that is what she's saying.
So how can we do something, say that was error?
Because the piece of evidence at issue requires no testimony whatsoever, it's strictly documentary, this court is authorized or empowered to look at it de novo and assess its own opinion as to what that fact is. And if the court comes to a different conclusion on that fact, then the trial court's decision is by implication erroneous, and this court is authorized to enter judgment in reverse.
I've spent a really inordinate amount of time looking at these photos, pulling in young members of my chambers to look at the photos, figuring my aging eyes, and let me tell you some of my questions for you.
Please.
So, for these purposes, it would be helpful if we were all looking at the appendix.
What page, Justice
I'm going to
Wolohojian?
start on page 26.
Thank you.
Straight to the end. Well done.
So on page 26, I see these green lines, and those green lines appear on a couple of the subsequent photos too. I take it that the green lines are meant to indicate property boundaries.
The green lines, the one that's going perpendicular and then the one that's going slightly to the right?
Well, on this one, the map has a red dot that says 9 Patricia Road, right? I'm looking.
RA 26, Your Honor?
I'm on page 20.
7.
I'm on page 27? I thought I was on
I thought you were
page.
on 27.
Are you
RA
on
27.
No, you're on 26.
You're on RA 26?
Oh, my bad. I'm sorry. She's on 26.
Am I on, maybe I'm on 25.
That might be it, yes.
Okay. It's in the top left corner, it says plaintiff 14.
Top left, plaintiff 14. We'll
Is that
do.
okay?
I have plaintiff 14 in front of me,
Great,
yes.
all right. So I see these faint green lines, and I take it the green lines mark the property boundaries.
The faint green lines,
According to like the
according,
deeds.
I'm not sure if that's what marks the boundaries to the property lines in terms of that, these green lines, the faint ones.
So 9 Patricia Road is the one that has the fence.
Yes.
And what I see is the fence, I think I see in the top left-hand corner of the fence, the raised bed
I think that you do.
within the fence. And I see the fence not going straight out to the driveway, to the road, but rather coming into the back corner of the house.
I understand what you mean. It's not going directly out to the road, but at a slight angle back towards 9 Patricia Road?
Well, let's just say we're all having it on the top, in the same orientation. I don't know where east, west, and south are, so I'm just going to talk about it as left, right, that kind of thing. The neighbor is the one above this house, right?
Correct.
All right. So the fence comes along the neighbor's property.
Along the
from left
border.
to right.
Correct.
And then it comes in to the
Yes.
corner of the house of 9 Patricia Road.
Oh, yes, it does.
What year is this map?
This map is 2007, RA 21 is 2017.
Okay, so let's look at the next page, which is RA, it's plaintiff 15.
Plaintiff 15.
It's the next page in the appendix.
I'm looking at plaintiff 15.
Same green lines. We can see the fence roughly in the same location, or in the same location, with some trees obscuring it a little bit.
Yes.
What year is this map?
This map is 2013.
Okay, so we can infer, because again, we can't see it, that the fence at this point is still taking a right angle, a 90-degree angle, and coming back into the back of the house, right?
Correct.
Because it doesn't go out to the street. All right. So then we get to the next one. What year is this one? Plaintiff 16.
Plaintiff 16 is a one from 2008.
Okay, so the trees aren't present. It's very good, clear image of the fence in the same shape.
Yes.
Okay. Then we have the next one, which is the winter scene.
Yes.
Plaintiff 17, with snow on the ground, no trees, and the fence is still in the same shape. What year is this?
This one is 2004.
Okay, so now we go to the next page. This is Record Appendix 29. We can't tell anything from Record Appendix 29 because it's from so far from outer space that we don't know what it is. But then Record 30, the next page, is the blow-up.
Correct.
Right?
It is the same image that, and this was an issue with the trial court. The first document is a 9x9 slide, and this is zoomed in. The second one is zoomed in.
Okay, and this is from the 1990, I forget which,
1998, from the
Okay.
National Oceanic and Aviation Administration.
Let's just call them NOAA. Can
NOAA,
we just call
wonderful.
them NOAA?
So I'm looking at this, and I see clearly, so the orientation on this picture is different than the orientation. So I understand that what is this line, what looks like a line going left to right,
Yes.
was actually going up and down on the previous images, because I'm going to assume that neither the road nor the house moved.
That's a
Okay.
fair assumption.
But then, so the fence line that we've been following in the previous pages, it came along the other property and then turned into the house.
Correct.
I can't see that here. I do think one could look at this and see a fence that goes all the way out to the street, or at least a line that goes all the way out to the street. Now, whether or not that's true doesn't really matter to me. What matters to me is that since this doesn't show clearly that a fence in the same configuration existed in 1998 or 9, whenever this was, as in the later photographs, how is it clearly erroneous for the judge to find that that it might not be what she called the fence?
It's not so much that the judge's decision is clearly erroneous. What it is that just as you, Justice, and I have gone through and looked at these exhibits, Your Honor's opinion trumps the trial courts. You have the same information in front of you. You are authorized to make the same finding. If you see the fence line differently.
So you're just asking us to do a straight de novo redo, look, not just a straight eyeballing it, and even though, all right. What
Could
do
I
you-
just jump
Yep.
in here, though, and say, if we were to conclude that this fence actually does run all the way to the street, so it's a bigger area, then I take it you're saying then we could find adverse possession of the smaller area that we can clearly see in the other pictures.
Yes, but what I think is important to recognize, and this didn't necessarily make it to Your Honors, is that the slice of property that's being adversely possessed is getting narrower the closer you get to the street. So by the time that you reach what would be right next to 9, where Your Honor, Justice Wolohojian was recognizing the fence turned into the house. That portion of the fence exists solely on 9 Patricia Road. It's not being adversely possessed. And it continues out to the street there is no adverse possession. It is a pizza slice as you go back, getting wider.
Okay, so, I mean, but this doesn't really help us too much, because if the fence, if the side of the fence that's closest to the neighboring property was different, we don't have any measurements to tell us where they are vis-à-vis the property line on RA 30.
If I may, if we can go back to any of the prior RA documents that you wanted. For instance, if we look at plaintiffs, I believe you may have had it at the snow scene.
Yeah.
The snow scene. There is a line that represents the fence that's going from left to right or from back to front of the property.
Yeah.
And then, as Your Honor, Justice identified, it moves down towards 9 Patricia Road. At that junction, where it moves down towards 9 Patricia Road, the testimony is that it is no longer adversely possessing the opponent, the other property.
Okay, but I'm just saying, so the part of this fence that runs left to right,
Yes.
okay, on the upper boundary,
Yes.
as in this picture, what's missing in my mind is if we look at R30, the 1998 photograph.
Yes.
I have no idea if this line that's running out to the street, where that is in terms of measurements on the property.
It's, so Your Honor believes,
It might be more, it might be less, it might be further to the neighbor, it might be closer. I have no idea. How are we supposed to guess?
it's not a matter of guessing. It is a matter of the line, just so that we're clear, the line that's actually to the back of the property going down is the same, it remains relatively consistent throughout all the images, whether it's the NOAA one or the other ones.
Well, except for this one goes to the street, it looks like.
Sorry, the one that's perpendicular to it, the back of 9 Patricia Road,
Okay, yeah.
is relatively consistent throughout all the images.
I don't know. I don't know if we know enough about length. Was there testimony concerning the, it looks to me like this 1998 photograph was taken from very far away,
It was.
right? And, and maybe not so much with respect to the other ones. Or was there any testimony as to the distance? In other words, I don't know scale. No one testified to the scale. I don't know if the scale in all of the photographs, no one says, no one, I believe, took the time to say plaintiff 14 shows a fence along the back boundary of 9 Patricia Road of 57 feet or whatever, and was taken from a distance of whatever, and then did that same thing for each of them. So I don't know how we are supposed to know that RA 30, the measurements of anything in RA 30. I guess that's the easiest way to put it.
The measurements in the NOAA photograph, the NOAA image, are not present. The analysis was taken in much the same way as Your Honor has done here today, with multiple eyeballs and people coming into my office and everyone laying them over each other and saying, does this look like this? Because the simple fact of the matter is the NOAA image depicts as I said in my brief, effectively a laser straight line that meets at an angle in the back of the property, or for you, it would be the back of the property, and then comes back across. And it appears to be in relatively the same position at the points in which it would be adversely possessing the neighbor's property to offer the inference, given the fact that we have all the additional testimony, or all the additional documentary evidence, that it makes it more probable than not, given the nature of this image, that this is a grainier version of or an earlier version and grainier version of the fence that's depicted throughout the remaining exhibits.
I take it you're saying, I think you're saying, if we were to take like a protractor that an elementary school student has and put it on the grainy 1998 photo, we would see that the angle of what seems to maybe be a fence is going to be the same in all of these, and therefore we can infer it's the same fence.
More or less, effectively. I mean, it's going to be, I don't know if the protractor will be delicate enough, but if you look at it with your own eyeballs and come to your own conclusions, that it appears as if, while it's not cleared, it's definitely grainy, that the angle that it's on and where it is most likely to be the fence that's depicted throughout the exhibits.
Let me see if there are any questions.
I just wanted to ask about your argument about the witness.
Yes.
I'm really baffled as to why where the Windsors live has any relevance to the application of the rule against hearsay.
There is, in the rule against hearsay as to the question was going to be, as we progressed throughout the minor portion of the trial, the case that I had anticipated serving them because they had lived in Massachusetts. I know that they had not appeared for their deposition, but I was going to bring them in for trial. And I sort of lost that opportunity when they had moved to New Hampshire to have done it effectively or had the time to do it prior to trial. I was looking at hearsay exceptions that could possibly come in, one of them being 803, number 20. But at that point, I think that one is one in which the declarant's availability is immaterial, but that would be a testimony for the history of boundaries. But the question really, the relevance for me at that trial moment was, and clearly throughout, has been the fact that I lost the opportunity to subpoena that person prior to trial.
You could have subpoenaed, I mean, there is a process for compelling out-of-state witnesses to appear at trial.
At the time that I realized he had moved out of state because he had been in state.
As a practical matter,
As a practical matter, I didn't have that opportunity. Or I didn't have the time to avail myself of that option.
Yeah.
Thank you very much.
Thank you.
Good morning. Members of the panel, may it please the court, Attorney Michael Zola for the appellee, Brandon Gonzalez. Your Honors, I'd like to begin with essentially where we just left off, the exclusion of the testimony of the private investigator. I'd like to just briefly mention that. In the appellant's motion to amend the witness list to include the private investigator, he claimed that Windsor was in fact residing outside of Massachusetts. In addition, the appellant detailed the private investigator's expected testimony. The appellee contends that Mr. Windsor was never residing outside of the Commonwealth, and I detailed this in my brief. All of Mr. Windsor's vehicles were registered in Massachusetts at that time. Windsor owned his home in Massachusetts. He had a declaration of homestead on the home. I ran a credit bureau check, which indicated he had a Massachusetts address, a current Massachusetts address. Social media accounts, be it as they may, Facebook and LinkedIn also indicated he was in Massachusetts. I even checked the probate court to see potentially if there was a recent divorce filing, to see maybe if him and his wife had separated and he had moved out. There was nothing, and there was also no claim from the appellant that Windsor was separated. The fact of the matter was he was in Massachusetts, and the fact of the matter is, as the appellant, I believe, has admitted, he just didn't want to get involved in this case. That's why he was not present. Further, the testimony outlined in the appellant's motion to amend the witness list, I'd like to just read some of the, it's essentially all hearsay. Mr. Windsor indicated that the fence was built in 1996 and 97. It's hearsay. Mr. Windsor remembers this date because he erected the fence for his newborn son, who was born in 1996. It's hearsay. Mr. Windsor hired Shannon Fence Company from BERXHIKU to build the fence. It's hearsay. Shannon Fence Company was responsible for measuring the property line and placement of the fence. Again, it's hearsay. The fence was not moved from the time he had the fence built to the time he sold the property. Finally, when Mr. Gonzalez purchased 7 Patricia Road, he never questioned Mr. Windsor about the location of the fence. Further, Mr. Windsor and Mr. Gonzalez would often talk at the fence line, and the fence location never came up. All of this is hearsay, and as the judge in the land court indicated, she described it as rank hearsay, and she properly excluded it. With respect, just briefly...
Is there a difference between hearsay and rank hearsay?
I do not know. One's worse than the other. With respect to admitting the private investigator as a rebuttal witness, now we turn to the trial. Mr. Gonzalez testifies just briefly as follows. I ask him, did you ever tell the plaintiff that the fence had been there for 20 years? His answer is no. Do you know when the fence was installed? His answer is no. Do you know who installed the fence? His answer is wouldn't know that.
So he purchased the property in 2015, his property.
He's discussing when the fence was...
Right, your client bought his property in 2015?
Correct, yes. And he's saying when he essentially moved in, he had no idea.
Right, they're both relative newcomers.
Correct, yes. So the appellant's argument that the PI should be admitted as a rebuttal witness should fail because there's nothing to rebut here. My client did not know who installed the fence or when it was installed. The PI was not present for any conversations between the parties. The PI never spoke to Mr. Gonzalez. And finally, the PI was not familiar with the disputed land as it was in 1998 and could offer no testimony to that effect. So in conclusion, the PI was properly excluded by the judge, and his inclusion now would serve no purpose as he has nothing further to advance for the appellant's case. Now, turning to the burden of proof that the land court judge applied, I'd just like to briefly read from the findings of fact a couple of paragraphs in the land court's decision. Specifically, number 23, paragraph 23. Justice writes, in a digitally enhanced enlargement of the portion of the 1998 photograph depicting the disputed area, there is a visible line in approximately the same location as the westerly section of the fence. However, due to the quality and resolution of the 1998 enlargement, it is inconclusive as to what existed in that location.
We have read the findings. You don't need to read them to us.
Okay, I apologize.
That's okay.
With respect to 23, 24, and 25, the court uses the following terms: inconclusive, impossible to determine, and no visible line which could be interpreted as a boundary.
What do you think of his argument that the three of us can look at it at de novo because we have the same documents in front of us?
Well, I believe it would have, the judge's ruling would have to be considered clearly erroneous, and I'm going to get into why I don't believe it was clearly erroneous, where I believe she actually did apply the proper standard, if I could.
Right, but there is case law that says that if the decision is based on documents alone, then we are in as good a position as the trial court judge to look at the documents.
Yes, Your Honor, that's correct, and I will say I'm fairly confident that this just...
Has that been applied to photographs?
Has that...
Proposition been applied to photographic or visual evidence?
I'm not certain, Your Honor. I apologize. Getting back to the land court's decision, the appellee contends that these words were integral to their decision. At trial, Your Honors, there was no direct testimony about the disputed land as it existed in 1998. There was no one available to testify that they were present on the land at that time, and what its conditions were, what was there, what structures were there, what structures weren't there.
Do you agree that the judge could have looked at the 1998 photograph and concluded that the lines depicted on there are the same fence that was there in later years?
No, Your Honor, and the reason, and I was actually just going to get into that, is I think we're comparing apples to oranges here, because the 4 other images were from Google Earth. They were not from a satellite. So it's different. They were obviously much clearer to the land court judge. And they were not enhanced, they were not enlarged. And one of the judge's concerns, and I believe she articulates it in paragraph 25, is the effect that that enlargement could have as far as distortion. And there was no testimony at trial as to what effect enlarging a 20-plus-year-old satellite image could have. So it's not the same as looking at an unaltered, unaltered Google Earth images.
So
we're talking about a different
is your
animal.
argument that the judge, as a matter of law, could not have looked at the photograph and concluded that it depicted the same fence? Because that was my question. I was trying to get at, could the judge have looked at this and said, you know what, it's sufficiently clear. That back angle one is pretty clear, the one that runs along the back of the property. That's at an orientation that looks pretty much the same.
But that really wasn't the dispute.
I know, but I mean, if you have a back line of a fence that's identical to a subsequent back line of a fence, and something that looks like it's running around the same place as the current sideline of the fence, wouldn't it have been a perfectly reasonable inference for the judge to say, yeah, that fence was depicted in 1998?
My belief, Your Honor, based upon the differences in the images, is that there just was not enough there to get over the 51-49 threshold. I think you could make an argument that it was 50-50, but that's not good enough now. Not good enough then, and it's not good enough now. I mean, did she have the option of doing that? Yeah, I believe so. I just think that because of the differences in the images, because of the lack of testimony from anyone that was there, or from anyone that could say, hey, listen, this image is enlarged, but that's exactly the way it should look. There's no distortion. There's no bending of the lines. We didn't have any of that. We just had to take the appellant essentially at his word that, yeah, this is a good image. This is what it shows. And I think that the land court was just not able to get over that threshold. Now, and that goes to another argument that we had that, I don't believe that the clear proof standard was the determining standard here. I think the court purposely mentions doubt on a number of occasions. And as I was reading in the findings of fact, we're talking about an impossibility the court mentions. The court specifically mentions distortion and the inability to determine whether there was distortion or not. And the court specifically says impossible to determine. So when you're using those words, I just don't see how you're then going to say, yes, it's more likely than not. Even though I think it's impossible to determine this, even though I think it's inconclusive, even though I don't have any testimony about this photograph, it's still more likely than not that this is a fence. I think the judge was at a point where it was 50-50 and the evidence, the appellant's evidence, was simply lacking. And I don't think that it follows that the Google Earth images, because they were, to the judge, over that threshold of 51-49, I don't think it follows that a satellite image, which is a different animal, and it's been enlarged, and it's from further away, follows that then we should assume, or for the sake of argument, it's enough that this fence was here in 1998. The evidence was lacking. That was my...
If we conclude that she did apply a, quote, clear proof standard, and that was incorrect, then what happens?
Well, Your Honor, if you conclude that, and it goes back, we're exactly where we started, which is we're looking at an image with no evidence that I believe that she did take into account or use the preponderance standard. And if she then uses that preponderance standard, and hypothetically you're saying she didn't and she used the clear proof, if she then applies that, I still don't think we're not over the 51-49 threshold here.
Well,
we're at 50-50.
On Record Appendix 44, she says a single grainy photograph does not rise to the level of clear proof required for the plaintiff to carry his burden. So what standard do you think she's applying?
And I believe the next sentence, Your Honor, mentions doubt in her mind.
Proof of adverse possession prior to April 21, 2004 being, quote, left in doubt, close quote. Mr. BERXHIKU is not established.
Thank you, Your Honor. Yes, I mean, that's what we're arguing, is that there's nothing that says it was sufficient for me, and the language I don't think bears that out, that the judge is saying it was sufficient for me that this was 51-49, but I can't rule in the plaintiff's favor because I have this clear proof standard that I have to apply. I think she's talking about two standards, but I think her language, at best, I think it's unclear. But I think her language is such, when you're using impossible and inconclusive and possible distortion, coupled with the lack of evidence that the plaintiff presented, no one's there at the time, there's no one to question about this image that they're bringing in. We're just looking at an image that's not as it was, but now it's enlarged substantially. I mean, it's from outer space, so we're enlarging it substantially. So when you take all that into consideration, I just don't see how, you could get over that threshold. I think it's 50-50 at best, and that's just not good enough.
Can I ask you a question that I meant to ask your brother, but then we ran out of time, so if you just can't answer it, that's okay. He suggests in a footnote that, invites us to look at a native digital image of the 1998 NOAA photograph. Was that native digital image introduced in evidence in the trial?
I
see him nodding. I'm pretending I'm not looking because it's your time, but.
I'm not certain, to be honest with
you. Thank you.
So in looking at RA 30, I mean, is there some indication there's distortion here? Because the neighborhood does look, just eyeballing it, like the pictures that were from Google Earth.
I mean, I'm not, Your Honor, I understand the question. I'm not an expert. I mean, I don't know whether it's, some structures would be distorted, some wouldn't. I can't tell, but I know the image has changed, enlarged, for lack of a better word.
Well, let's come at it a different way then. Were the exhibits at the trial in color, or were they also, was this 1998 photo in black and white?
I apologize. I believe they were in color.
What are the green lines? Do you know on the later photographs?
Your Honor, unfortunately, my printouts are in black and white, so the green lines you've been referencing, as my brother was speaking, I was unable to, I was trying to figure out which ones those were, but I did not, was that in?
It's in all of the Google Earth ones.
In all of them?
They're like an overlay on the photo that look like something you might use for citing.
Right, my brother just handed me a clear copy. Yeah, that's correct. It looks like an overlay.
So there's no, of what? Do we know? Is it measurements, plot lines? What is it?
I mean,
It may be the latitude and longitude. I'm looking at the white box that popped up. It may be some sort of, I suspect that's what it is, although, let me see if it's, yeah, because if you look at each picture, the latitude and longitude, I believe, are the same.
I don't know. I mean, if you look at the house across the street, some of the green lines go right through it, so I'm hoping that's not a property boundary.
No. I think this is almost like X marks the spot with the latitude and longitude. That's my uneducated guess on that.
Okay. And there's no equivalent for the 1998 photos?
No, and that's why, and that goes back to my point, Your Honor.
Okay, but your time, so I think we're all set. All right, thank you both.
Thank you very much.
Thank you. We appreciate your argument and your submissions. The case is submitted. The next case is 2022 P0341, Daniel Chapoteau versus Bellard Sante, Inc. Is it Attorney Moslinger?
Correct, Your Honor.
Okay, we're ready whenever you want to get started.
Good morning, Your Honors. May it please the Court, Raven Moslinger on behalf of the appellants. The Sunday closing laws begin with one general prohibition, and that is that on Sundays, no business activity may take place whatsoever. Now, of course, over the years, the legislature has grafted on a number of exemptions to that general prohibition, and now there are 50-plus types of commercial activities that may take place on Sundays. But it is still the case that if you engage in business activity that falls outside of an exemption, you're in violation of the Sunday closing laws. Now, on Sundays, Sante, the appellees, engages in 3 distinct forms of commercial activities. Number 1, it provides hair cutting and beauty services, and that's specifically exempted by the statute, and that's permissible. Number 2, it engages in massage services, which again are specifically exempted by the statute and permissible. The third thing they do, and the reason why we're here, is they sell retail beauty products on Sundays, and they do not pay premium pay to their employees, and there is no exemption that permits that. So every Sunday that Sante opens, it opens in violation of the Sunday closing laws.
So you're saying that they need to say, I'm sorry, we can't sell you any product today on Sunday, or they have to pay premium pay?
Correct, Your Honor.
So one question I have is, why would they need to pay premium, like if just the person at the desk could sell the product, why would they need to pay premium pay to everyone else? In this instance, the example I could think of was a Cracker Barrel, right? You go, walk in, you're in this little shop, basically, and there are people who work the register for that shop, and then the next room over is the dining room, and you have wait staff.
Understood, Your Honor. The statute provides that you only have to pay premium pay to the people who are connected to providing sales services, not to everybody.
Where do you see that?
That is in the text of subsection 50, and I can read it verbatim here. But subsection 50 provides that.
Oh, engaged in the work performed on Sundays.
Correct, exactly, Your
Okay.
Honor. So only the people who are
if they're-
engaged in sales.
So would that be actually engaged as opposed to hypothetically engaged?
Well, Your Honor, I don't know that that legal question is before this court. My view would be that if that's one of your duties, and let's say you don't successfully make a sale that day, you're still entitled to Sunday premium pay.
All right, so I'm going to go back to your first point about prohibited activity. Your clients wouldn't have standing, maybe you think they do have standing, to pursue an alleged violation of Section 5, just that you engaged in selling products that you're not allowed to on Sundays, because it provides for fine. So that's usually, right, criminal prosecution to get the fine or something. Your clients couldn't pursue relief under Section 5.
Correct, Your Honor.
Okay. So with respect to a violation of Section 50, well, Section 6, paren 50, subparagraph 50, that says that it's to be enforced by the Attorney General.
Well, Your Honor, the issue of a private right of action was not raised at the trial court level, and I believe that that's what you're raising right now.
Yeah, I'm trying to understand, because...
So the Wage Act provides that you have to pay employees their earned wages, and wages mean wages. Sunday premium pay is a form of wages.
All right, do we have what's the case that ties the enforcement of the Wage Act, which your clients would have standing to do,
Sure.
to violations of Section 6, paragraph 50?
So two things.
Is there any case where we've seen that done?
Drive-O-Rama. It's not directly on
Drive-O-Rama?
point. This court's decision in Drive-O-Rama, it was a Wage Act violation. The Attorney General had brought suit against a store that was operating on holidays and not paying holiday premium pay. The holiday pay statute requires premium pay on certain holidays, and it has that exact language. It says shall be enforced by the Attorney
Right.
General. And it also has the exact same premium pay requirement. And this court found that there was a Wage Act violation, upheld a finding of a Wage Act violation with respect to the failure to pay premium pay on that Sunday via the Wage Act. So that would be the case. There's also some trial court level decisions that have found that there's a private right of action under the Wage Act with respect to Sunday premium pay.
Can I pause you for a second on Drive-O-Rama, because that's an Attorney General case, so.
That is correct, Your Honor, but it is a case that affirmed a violation of the Massachusetts Wage Act itself. And the Attorney General has parallel authority under Section 148 of the Wage Act to commence those sorts of actions for the failure to pay earned wages.
So this would be the first appellate case where we would say that there's a private cause of action under the Wage Act for a violation of Section 6, paragraph 50?
It would, Your Honor. This didn't come up at the trial court level. I would love the opportunity to brief the issue if the court's going to deal with it. Had it come up, we would have briefed it. But a few things I'll note, Your Honor, is that there is the Drive-O-Rama case, and there's also a history of the Wage Act being stretched to cover provisions like premium pay. In the Drive-O-Rama case, in the Crocker versus Townsend case, the Supreme Judicial Court said that under the Wage Act, you can enforce the overtime law, which is a separate statute. In Fernandez versus Attleboro Housing, the Supreme Judicial Court held that under the Wage Act, you can enforce the civil service statute separate and apart. And in the Sleepy's case that the SJC recently issued, Sullivan versus Sleepy's, there was an implicit finding that you could bring a Wage Act claim to enforce the Sunday premium pay statute. So I think that there's a great deal of authority that provides for that. Do you have any further questions on that? I'm happy to.
I'm wondering if there was any effort to bring the Attorney General into this case?
We filed a complaint with the Attorney General's office with respect to this and received a private right of action letter permitting us to sue in court. So generally speaking, once they issue that letter, they don't engage in their own investigation. So, Your Honor, sort of turning back to this exemption that's at issue, which is the store or shop exemption, it provides that a store or shop can operate on a Sunday so long as it and sell retail goods so long as it pays premium pay to employees. Sante argues that it doesn't fit that description because it's not a store or shop. But if you look at the plain text definitions that both parties have submitted, it plainly falls under that.
I don't understand that argument that they're making, to be frank, because if they're not a store or a shop, then it seems to me they fall squarely within the any business language of Section 5. So how does that help them?
I don't think it does. I think they fall within the plain text definition of what a store or shop is. A shop is just a place of business. And a store is a place where traffic is carried on in goods.
So is your position that they do fall within paragraph 50 or that they don't?
That they do, but they fall within it, but in violation of the provision by failing to pay.
But if we were to find that they don't fall within, that they're not a store or shop,
well,
what happens? What happens to your cause of action?
We would lose, frankly. If you found that they were not a store or shop that fell within subsection 50, we would lose. But
because the only solution then would be to fine them for all the days that they violated the statute.
Well, that would be a separate enforcement action as to the Attorney General. But
it wouldn't be something that you could pursue.
Correct. But many of the wage statutes have commandments, and they say you must pay this, you must pay that. And when an employer fails to pay that, the employee can bring a claim and say, I was not timely paid my wages under the Wage Act. No matter the source, and for them to operate on Sundays pursuant to subsection 50, they must pay the premium pay. And I think it's abundantly clear that they fall within the definition of a store or shop required to pay that premium pay. The other argument that
Well, the defendant make a slippery slope argument that if we rule in your favor, we're going to be opening up tons of businesses to premium pay for the last 3 years.
Well, there's no evidence in the record that there are a bunch of businesses out there that aren't paying premium pay to people who make payments to sales employees. And so, you know, I think the First Circuit said this, hyperbole isn't a great tool of statutory construction. Just the opposite could be the effect, that you're permitting Sante to sell retail goods on Sunday without paying premium pay is giving them a leg up over the competition that is in fact paying premium pay to employees. And again, this is an employee-friendly statute. The SJC has told us that the premium pay requirement in the statute is to encourage, or excuse me, to discourage employers from having employees work on Sundays and to reward employees when they do. And so, Your Honor,
given that the premium pay portion of Section 50 is going away, like in a couple weeks, what, I understand why it would matter to your clients, obviously, whether they're paid, because they've got years' worth, they hope, of premium pay behind them. But what what legislative intent, I mean, part of what has interested me about the statute, which I have all kinds of analogies for, but I'm going to keep them to myself, is that it sort of charts the path of the Commonwealth away from a notion that, you know, there's some kind of religious aspect to government oversight. And it seems that the newest changes really just give up on that altogether. Part of what one always thinks about is interpreting legislative intent is sort of where was the legislature going with this? And it's pretty evident that now the legislature is going away from what your client says is important. Is that something that we need to consider? Is that, I mean, it seems bad for you, but maybe irrelevant?
I think it's irrelevant, Your Honor, because when you interpret a statute, you interpret it from the date of its enactment. If it changes down the road, then you can interpret it as of that effective date. January 1st, 2023, you can look at it and maybe there's a different intent. The elimination of the premium pay requirement arose from a grand bargain between the governor and the legislature that also resulted in an increase in the minimum wage. I just don't think it's relevant here. So my time's a little short here, so I want to skip to sort of I think the key crucial legal question in this case, and that is, it's clear that Bella Sante's activities implicate 3 different exemptions. So what does that mean? What's the implication of that? The trial court reached that conclusion. It said, it looks like, based on the evidence, they're a store or shop selling retail goods on Sunday, they're engaged in massage services, and they're providing haircuts as well. That implicates 3 exemptions. But the error that the trial court committed was that it effectively held that Bella Sante engaged in some exempt activity, that being haircutting and massage services, and that by virtue of that, it was allowed to engage in unlawful Sunday activity, which is to sell retail goods on Sunday without paying premium pay.
So is your colleague correct that it is undisputed that most of the product sales or all of the product sales were ancillary to the services performed?
The 22%, sure. 22% of their revenue comes from the sale of retail goods. But that doesn't matter for purposes of the statute. And you can look at Commonwealth versus Graham. In that case, you had a common vindler who was operating a cafeteria on Sundays lawfully. And she was convicted of violating the Sunday laws because she sold some cigars. Her defense was, I'm primarily a vindler. And I just so happen to sell some cigars. And the SJC said, well, if you were just a vindler, if you were just a cafeteria, maybe you're not a shop. But if one purpose of opening on Sundays is selling cigars, you're a shop under the statute. Same issue here. The amount of sales activity doesn't matter. There's nothing in the statute that suggests that there's a line to be drawn between the amount of sales activity that's taking place. It just says retail sales. And there are other provisions in the Sunday exemptions that do draw a line. They say, for example, if you're primarily operating a pet store, that makes sense, right? If 51% of your activity is a pet store, then you're exempt under the statute. But subsection 50 says nothing of the like. There is not the word primarily. There is no line drawing to be done. And I think two things. One is this court's decision in Drive-O-Rama hit home on that point. In Drive-O-Rama, you had an employer who was operating a store, and they were doing so on Sunday, and they said they were doing it pursuant to a Sunday gift shop law that doesn't require premium pay. But separate and apart, they were operating on holidays that required premium pay on holidays. And this court said, you can't just operate pursuant to one exemption and then ignore other implicated exemptions. You have to comply with all of them. And it required that they pay premium pay under the Massachusetts Wage Act, which is precisely what we're doing here.
What's your basis to request attorneys from us now just for this appeal?
It's a Wage Act claim.
Well, but don't you have to win the whole claim before you get the attorney's fees?
That was not my understanding of the authority. My understanding is the winning of the appeal under the Wage Act would provide for it.
And that's if you won that there was liability, or?
Just the appeal period. Your Honor, and the other case I would point to is the Commonwealth versus Great Atlantic case. That was a case where the defendant's store was engaged in mixed activities, some that were exempt and some that were not exempt. And they took the position, they said, well, we have an exemption here that allows us to sell exempt goods, so we're allowed to sell non-exempt goods as well. The SJC
We
rejected...
saw your argument in your brief about the AMP case. Let me see if there are any other questions. No, thank you. I think we're going to have to leave it there.
I think we've reached the afternoon, so good afternoon. My name is David Rich, and I represent the Bella Sante defendants. Your Honors, I think the issue here, if the blue laws are interpreted in the manner that they are suggesting, the proverbial exception will swallow the rule. And we have 56 categories.
Okay, that may be. However, which of the laws authorizes Bella Sante to sell retail products on Sunday?
So Bella Sante is operating pursuant to Clause 54 and potentially Clause 55.
Where do those say they can sell?
55 is a banking operation.
54.5, I'm sorry.
Yeah.
It does not say. But, Your Honor, if you look at the statute, you start with the statutory language in paragraph 50. The trigger for an obligation to pay Sunday premium pay is a store which qualifies for an exemption under this clause.
First, can we just stop for a minute?
Of course.
You would agree that Section 5 puts a blanket prohibition on commercial activity on Sundays?
I agree.
Okay. So unless something falls within one of the exceptions of Section 6, it's prohibited.
Correct, one of the 56.
So, let's look at Section 54, because I take it you're relying on your client's ability to stay open and conduct business on Sundays on 54 and 54.5.
Correct.
Okay, 54 does not say anything about selling goods. Can we agree on that?
We can agree on that.
Nor does Section 54 and a half.
I agree with that, although arguably 54 talks about beauty services, and under the umbrella of beauty services may include people
Do you have a case for that?
I don't.
Okay, so let's just take it as services, because the statute itself uses the words goods and sale.
I understand.
So we are going to be bound by whatever our case law says in terms of
Agreed.
rules of construction. So if you have a case that says we can construe services to include the sale of goods for the purposes of these exemptions, now is a really good time to tell us.
I don't have a case.
Okay, so let's assume that we take those two provisions as they are written. Those two provisions do not permit the sale of goods on Sunday.
I actually don't agree that I believe our position, if you are operating under one of those exemptions, you have the right to undertake ancillary services which aren't within the literal words on that.
Okay, so what do we do with the fact that there are 50 some odd other provisions in this statute, some of which say exactly what you're arguing? They actually explicitly provide for the sale of ancillary products, but these two do not.
Well, let me we'll give two examples that fall into the 53 that do. How about section 24 and 28? 24 is the making and baking of bakery products and the sale thereof in a shop or store. 28, the retail sale of greeting cards and photographic films. So does that mean, and I believe it does not, that if someone goes into a retail, wants to buy a greeting card, and they want to buy a balloon, or they want to buy a postage stamp to mail the greeting card, that they have to pay Sunday premium pay? That can't possibly be what the legislature...
I don't know the answer to that question, but you are relying on sections 54 and 54 and a half, and they do not provide explicitly for the sale of goods.
I understand, but my argument is that that they are reading section 50 as an umbrella, that if there is any retail sale that is going on in any of the other 55, then you have to pay Sunday premium pay.
True enough, and I take that point. You may not satisfy any of the exceptions.
Well, I disagree, but.
But you may not, right? In which case, your client's going to be thrown into the prohibition of Section 5 with its attendant criminal penalties. So maybe the best thing is to turn to Section 50.
Well, Your Honor, I will turn to Section 50, but I do think it's important when you're interpreting the entire statute that the manner in which they are seeking to interpret is an over-reading of the requirement. And the reason why I say that is, if you look at there are three of the 56 that you can't open on Sunday without paying Sunday premium pay. There's 50, which we know. There's 25, and there's 27. And 25 is the sale of tobacco products, soft drink, and 27, the sale of retail drugs and medicine and personal health and safety. It can't be, those 25 and 27 would be mere surplusage if 50 is read in the way they are, because they are undoubtedly selling products in a store or shop under 25 and 27. So what that means, respectfully, is I believe what the legislature did was they said, here are 55 types of businesses that can be open on Sunday. We'll go through all of them. If you aren't any of those, we're going to set a number 56, which they called 50. And it says, as sort of the backstop, if you don't fall into any of those 55, but you want to be open on Sunday and you're selling goods, the price for you is Sunday premium pay. And while it's only a Superior Court decision, that's exactly what the Galloway case from the business litigation session said. That was a case I think they were offering, it was a call center. And Judge Davis said, I've looked through all 55 of these, and none of them seem to apply to what you're doing. So no other exemption comes close. So I'm going to put you into 50, and you're obligated to pay Sunday premium pay.
So if we were to conclude that neither Section 54 nor 54 and a half helps you, okay, your sale of goods is not covered by either of those sections, you're now arguing that you fall into paragraph 50?
No, I'm not arguing. I'm
Okay.
arguing our right to sell goods ancillary goods on Sunday derives from the fact that we qualify for an exemption.
All right, I'm going to ask you to assume one thing.
Sure.
You don't qualify under 54 or 54.5. What then? That's what I'm trying to understand.
If we don't qualify under that exemption, then we have no right to be open on Sunday.
Okay, at all?
No.
Well, you can't even open to provide the goods that are allowed, the services that are allowed under 54 and 54 and a half?
The goods that are entitled under...
Not the goods, the services.
No, because you said we aren't able to open under 54.
If the sale of goods is not covered, your sale of goods is not covered by 54 or 54 and a half, what then?
Well, then my clients couldn't sell goods on Sunday, or they would have to pay Sunday premium pay to everyone who works there, including Mr. Shapoto, who in 3 years sold one good on Sunday.
Okay, but how do you get there? Because what I believe your brother was arguing was the question of who gets paid and how much is not before us. Because whether people are engaged in the work performed on the Sunday would seem to me to be a question for another day.
Well, yes, that issue wasn't addressed because the court dealt with this issue as a matter of law. But if you read their complaint, they're asking for, they call them, the class they seek to have certified are spa workers or spa employees. So every esthetician, every manicurist, every hairstylist,
Right, but that
every
doesn't mean
masseuse.
that doesn't mean that they'll get compensation for every minute of work. If you have a massage therapist who everybody agrees spent 50 minutes out of 60 doing massage, that may not mean they get premium pay for those 50 minutes, but they do for the 10 they were upselling.
Well, you're right. That hasn't been briefed. But their position is that if as part of, you just heard them say, if their job responsibilities involve potentially selling something, then they qualify. That's their argument. And again, that's not before you. But their argument is, no, you don't get to say, well, you were selling for 15 minutes or trying to make a sale for 15. It's all bets are off. And
So-
that's why we, again, I come back to the fundamental proposition that they are operating their business, the right to open on Sunday is under 54 and 54 and a half, and their ability to sell ancillary products is what the examination the court did. About 1% of the floor is dedicated to doing all of these things, and that's really what I think the court.
But if you go, like, let's say you walk into Star Market at 9:30 a.m. on a Sunday, and you pick up eggs and English muffins, and you're having people over, so you also go to buy a bottle of sparkling wine because you want to make a mimosa. And you get up to the front desk, and they're going to say to you, I'm sorry, we can't sell you the sparkling wine because it's too early in the day on Sunday. So Star Market can be open, it can sell the things that it can sell, but it can't sell things that are in violation of another section. Why isn't that like the spa being open and being able to provide spa services, but not sell stuff?
Well, I think the not being able to sell alcohol is a little bit of apples and oranges. I understand the analogy that you're trying to draw. And again, our position is if you interpret the statute in the manner in which you are, then essentially all 56, or the overwhelming majority of them, will be required to pay, until the statute changed, Sunday premium pay, because as we go through the analysis in the examples, virtually every single one of these businesses has some ancillary sale, and that's why Judge Ham's decision in this case and Judge Liebensberger, again, Superior Court BLS decision, talks about if the legislature wanted to require premium pay for all retail sales made on Sunday, they could have just said that. But instead, what they did was they chose a very limited and finite category of business.
And with all due respect, the legislature did say that. That's Section 5.
Well, but then the legislature went on to
It
say
made some carve-outs.
53, you don't have to pay Sunday premium pay, and 3, you do. And so what, in effect, they're arguing, and the statutory interpretation is that 50, again, serves as a blanket or an umbrella, that if you sell one retail good, in addition, while operating under any one of the other 53, you have to pay Sunday premium pay. And if that's, I'm sorry.
Let's back up, though. Did you agree below, did both sides agree below that the facts are undisputed? There's no factual question about, like, the massage therapist says, I've done this massage, but to keep your muscles supple, you should use this Tiger Balm every day. Like, that seems like that arguably could be under a massage service.
There was no Tiger Balm discussion in discovery, but I understand your point, yes.
But what I'm trying to ask is this, do you both agree this is purely a question of law?
Yes.
Okay. And when you say that 50 makes 25 and 27 surplusage, was 50 implemented or adopted by the legislature much later? Or were they all adopted at the same?
I know 50 was, I think.
50 was in 1982, right?
Right, and I did know the answer to this question at one point, and I'm sorry, it's not at the head of my head.
I take it what you're arguing is that even though you may not fall, the sale of goods, your client's sale of goods on Sundays may not be protected under Section 54 or 54.5, that doesn't necessarily mean that you're automatically thrown into exception paragraph 50.
Yes, and again, I'm going to cite to you the Smith-Berry case, which again, Superior Court, BLS, but very well reasoned. In that case, what happened is it was a movie theater that served, these movie theaters where you can go and get a hamburger or whatnot. And there were a lot of issues about holiday and this and that, but the one part I would direct you to, in addition to footnote 4 in the Attorney General's opinion or on that, was they were selling candy and soda, but they were also selling meals. And what the Superior Court, again, just the Superior Court, but I think the reasoning is sound, said such business qualifies for an exemption under Clause 42, not 25. And so, because I think and 42 is running basically a restaurant, I think a victualler, I forget, I can't pronounce it.
Right, but 42 is conduct of the business of an innholder or common victualler. So that's pretty broad, business. That's not what we've got in 54 and 54 and a half.
But what they were arguing was, because you're selling soda and candy, that is specifically prohibited from being sold on Sunday without paying Sunday premium pay. And the court said, no, we got to look at this. You have to look at what you are operating under, what window you fall in, and if you sell ancillary services under that, it doesn't transform you into something else. And again,
Right, but the challenge I see with that is 54 doesn't say a hair salon, which, because I'll grant you, I've never seen a hair salon that does not try to sell you product. That's how they make a lot of money.
Right.
But it doesn't say hair salon. It says that it's the cutting, it's this action. It's an action item, the cutting and styling of hair and the furnishing of beauty services.
of related beauty services.
Yeah, 54.5 doesn't say a spa or a massage therapy spa. It says the performance of the service of the massage.
I understand, and I'm out of time, so I don't want to overstay my welcome. Can I answer the question?
You may answer that question.
Your Honor, again, it really, the exemption under which my client is operating are those two. And so long as the prevalent source of their work is operating under those two, the sale of ancillary goods, which serve the common purpose for which you are open on Sunday, cannot and should not constitute a Wage Act violation. For the reasons that we say in our brief, you can make this argument for not every single, but probably 30 or 40, you can tick off the list, saying you're a car wash, you're a bakery.
Sure, but there may be a lot of employers who aren't satisfying the requirements of the statute. So, I mean...
I agree with you, but again, it comes back to what's the legislative intent. What was the intent here? And if they wanted every retail sale to be covered by this blanket, it would have been really easy to say that instead of doing it in the way that they're arguing. So it's a statutory construction argument. It's not how many, we're violating the law too, so have mercy on us. That's not the argument I'm making.
Thank you. Thank you both for your arguments. It's an extremely interesting case, and the case is submitted.
Thank you, Your Honor.
The last case that we'll be hearing this morning is 2022 P0412, Airport Fuel Services versus Martha's Vineyard Airport Commission. And I understand there's going to be a division of time. Can you just tell us how that's going to work?
Yes, Your Honor. We will be dividing the time between the appellees, 12 minutes for me for the Martha's Vineyard Airport Commission and 3 minutes for Depot Corner.
Great. Thank you.
Good afternoon. May it please the Court, Dana Curran for Airport Fuel Services. The question in this case is which provision of General Laws 30B applies in the present circumstances, whether it's the relaxed requirement of Section 16, which governs the rental of governmental land for specified uses, or whether it's whether the agency was required to follow either Section 6 or something approximating Section 6 based on the requirements contained in the RFP.
So your learned colleagues say that this was all previewed with your client and they knew what section the airport was relying on, and you didn't say anything. And now you're trying to say, well, they used the wrong section.
Well, okay, we're not necessarily claiming that the RFP was unlawful. We are challenging the way it was applied during the procedures. When you look at the RFP itself, the first paragraph of Section 2.1 provides, attention of all proposers is directed to Chapter 30B, Section 16, governing the transaction of real property. But the fourth paragraph on the same page says, the proposer's attention is directed to all applicable state laws, municipal bylaws, and the rules and regulations of all authorities having jurisdiction over this real property transaction, which shall apply to the contract throughout, and they shall deem to be included in the contract. So, you know, that opens the door to Section 16 certainly applies, but some of the other sections, including Section 6, may also apply. And when you look further into the RFP, it goes on to list and describe the comparative evaluation criteria. The fifth and last of which, by the way, is the amount of rent paid. In a government procurement contract under Section 6, bidders submit the price and non-price portions of their bid separately, and the agency is supposed to go through and consider both and consider not just price, but all of the other criteria.
You argue that the determination of whether this particular process fell within, was governed by Section 6 or as opposed to Section 16 is a question of fact. I'm thinking that must be at least a mixed question of law and fact.
I think it probably is mixed. I mean, I think my argument is that as a matter of law, the trial court should have ruled that Section 6 applies as well, but at the very least, if it's a mixed question, it should have gone to a finder of fact and should not have been decided against us on summary judgment.
Well, if you have enough facts to say that that may be true, if there's enough to get you a triable issue of fact as to whether this contract or this bid, this RFP was controlled by Section 6. And so far, all I've heard you point to is this sentence in the fourth paragraph of 2-1.
I think when you look at the RFP itself, when you look at all of the attachments, particularly attachment 16, it describes the evaluative criteria, comparative evaluative criteria, and it compares, quote, the specified services, and the specified services being the ability to operate a gas station. And so I think if it was just looking for price for the highest bidder, then yes, Section 16 would probably be the exclusive section under which this should be evaluated.
So I don't understand, and if you could point me to a case that would be helpful, how a process like this would go forward if more than one of these sections applied. For example, just to take the most obvious thing, one of them requires opening the bids in public, and the other doesn't. How do you have a case where both Section 6 and 16 apply?
I don't think I have a case where there's a blended proposal. I mean, again, I think this is a case of first impression. Judge Nickerson looked at this on a motion to dismiss and said, you know, when a case, I probably shouldn't paraphrase him, I should probably look at it. The question of when an RFP shifts from the rental of governmental land for specified use under Section 16 to the procurement of operations of such use on that land under Section 6 appears to be one of first impression, and I would tend to agree with that.
So just to use his language then, shift implies to me that you are no longer in one world and you have moved into another world. Is your argument that this is removed from the Section 16 context altogether?
It may not be removed. I think you have to consider both. And I also think that I think the RFP includes requirements from both sections. This should have been, this RFP is not a model of clarity. It probably should have been drafted more carefully. But
If we were to conclude that the RFP falls within Section 16, in what way did the process fall short of the requirements of Section 16?
well, I mean, I think you have to look at how the MVAC treated the proposals. They did not go to the highest bidder. The highest bidder, there was actually a party that bid $5.
I'm just asking about the process. Maybe my question wasn't clear because I'm going to have the same question for Section 6. Section 16, assume that we were to conclude that this RFP is governed by Section 16. In what way did the process not conform to what's required by Section 16?
I think there are some inconsistent parts of the requirements. First of all, Section 16 requires that bids be open in public. Section 6 requires that they be open in private. In this case, they were open in private.
So in that way, Section 16 would not have been satisfied, but it seems to be agreed that there was no tampering with the bids, so what harm would there be? I don't know. But
well,
in any event, I'm looking for a list. So you've got Section 16 requires that the bids be opened in public, and they weren't. Is there anything else that happened that ran afoul of Section 16?
I mean, Section 6 requires...
16. I'm
She's
sorry.
going to get to 6 in just a moment, don't worry.
Section
16 does not require, for example, that there be a committee appointed to evaluate the bids.
Right, so I guess the answer is no. The only problem would be with respect to Section 16 that the bids were opened in private rather than public.
Yes.
Okay, now let's turn to Section 6.
Before we go there, I just want to make sure on 16, they weren't obligated to take just the highest bidder, right? They could look at other criteria?
They probably could, yes. I mean, I think they could look at whether somebody had the ability to pay the stated amount. I'm not sure if they could necessarily look at their experience operating a gas station.
Okay, so then under section, if we were to conclude this is a Section 6 process, in what way did they fall short of Section 6, process-wise?
Process-wise, I think they did sort of an ad hoc committee that the chair said, you know, the head of the
It was
airport
not formally
commission.
constituted.
It was not. The criteria was sort of something that he came up with. It was really seat of the pants. And I think I mean, I think there was the way it was applied, the way the criteria were ultimately applied.
That's not a process failure.
That's probably a result
Yeah.
of this.
So what I hear you saying is that if this falls under Section 16, then we have a claim based on the fact that the bids were opened, weren't opened in public. And if this is a Section 6 process, then we have a claim because there was not a formally designated committee to consider the bids.
And it was unclear what the criteria were that were considered. That they came up, again, Mr. Garfinkel came up with a numbering system, and he sort of made it up on the fly. And it was not very formal. It was just sort of seat of the pants. And then what ultimately happened was Depot was granted the bid. Their bid was granted, but the lease they signed was not actually what they agreed to. So, for example, there's a provision, Section 4.8, that revisits the market rent, or the rent, every 5 years. And there's no definition of market rent, but that market rent would appear to be probably something below what its initial bid was. It could be the $1.58 or whatever that figure is in the minimum bidding requirement. That bid over the course of 20 years may end up being, the amount Depot pays may end up being substantially less than what we bid. And that was, by the way, Depot was also excused from the requirement in their proposal that they run a lube and auto service facility. So it ended up being, the bids ended up being apples and oranges, and my contention is that that using this flawed process, a less favorable bid was actually accepted. One other thing is Airport Fuel was in the process of selling this, its business, and upon the sale, the judge notes this in his decision, there would be a 3% transaction fee plus a 10% premium for a sublease fee, which probably would have ended up being substantially more than Depot ended up paying. So, it's not just we weren't the high bidder and we don't like the way things came out. We weren't the high bidder and we don't think the process was transparent or fair or compliant with the requirements of either the RFP or Section 6, which we contend applies. That's really where we are.
So on their 93A claims, why are they not allowed to bring a 93A claim against your client?
I think because this was there was no showing of that their holdover was violated 93A. The bid was brought, or the results of the bidding process were decided on the last day of the lease. And yes, my clients did hold over. They were evicted. They removed they were out of the premises after a few months. They paid the rent, but they ended up removing the buildings. So
during the time that they were there, they continued, during the holdover, they paid rent?
They paid rent.
And MVAC accepted the rent?
My understanding is they did.
Okay.
There may have been a breach of the lease. I'm not sure if it would have been, I'm not sure if they could have gotten out on the day that the bid was announced, but it was nothing more than a breach of contract, certainly nothing rising to the level of 93A.
In your statement of facts, it was taken entirely from the judge's decision on the motion for summary judgment, the judge's findings of fact. But you also say that this court is to conduct a de novo examination of the evidence in the summary judgment record. How do those two things go together?
Well, I think for the purposes of my brief, I summarized what the judge said for a statement of facts. I don't agree with everything the judge said, but for purposes of the brief, that's what I did. But I think the standard is that there is a de novo review.
But you don't point to parts of the record that you think support a conclusion that's different from what the judge concluded in the summary judgment decision.
I think I do in the argument section.
Okay.
Unless there are any further questions, I'll leave the remaining points to the brief.
No. No.
Thank you.
Thank you very much.
Good afternoon, and may it please the court. My name is Christina Marshall from Anderson and Krieger. With me, David Mackey for the appellee and cross appellant, the Martha's Vineyard Airport Commission. Airport Fuel argues on appeal that the Superior Court erred in granting the MVAC summary judgment in a bid protest case where Airport Fuel was outbid by the winning bidder by over $350,000 over the course of the 20-year lease. The Superior Court correctly concluded that the RFP issued by the MVAC was properly issued under Section 16, which applies to leases of land. I'll briefly address those issues on appeal, and then I'll turn to the MVAC's own counterclaims, which stem from Airport Fuel's wrongful refusal to vacate the property at the end of its lease in 2017. On those claims, this case raises an issue that doesn't appear to be previously addressed in Massachusetts courts, and that is if a commercial lease on property expires, but the tenant remains on site, continues running a profitable business using the property, is the landowner truly limited to fair market value rent, or can it also force the tenant to disgorge its profits as damages? Airport Fuel's main argument in the appeal is that Superior Court erred in ruling that the RFP was issued under Section 16 of Chapter 30B and argues that it should have been considered a blended proposal under also Section 6 of Chapter 30B. On the facts, it could not have been more clear that this RFP was issued under Section 16. The RFP stated in bold, underline, all caps that it sought to dispose of the underlying property only. It makes no references to any services to be provided to the MVAC, nor does it state that the MVAC was seeking a bidder to operate a gas station. There's a single reference to a gas station in the entire RFP, which is simply a notification to bidders that one existed on the property, and they had the option to either purchase that from AFS or ask that the improvements be removed at the end of the lease term. The RFP itself described the use of the premises as anything that complies with federal and state law. The sample lease attached to the RFP left the permitted use blank, and AFS's own lawyers knew as early as 2008 that the land would be bid out under Section 16 and never raised any concerns with this until this lawsuit. Plainly, the bid should have been correctly issued under Section 16. Having established that...
Do you know why there's a difference in how the bids are open, whether that they're supposed to be open in public under 16 and private under 6?
I am not aware of the legislative purpose behind the difference in the requirements between those two sections.
Section 16 doesn't seem to set up this kind of comparison of evaluative criteria the way Section 6 does, but this bid process, or at least the evaluation of the bids, did include that kind of process, which seems weird to incorporate that from Section 6 into a Section 16 evaluation.
Certainly was not required by Section 16 that the MVAC include that comparative evaluation criteria in the bid. Judge Kaplan addressed this at the very beginning of the case in the preliminary injunction decision, noting that the MVAC had borrowed some elements from Section 6, but that mere fact alone was not enough to somehow transform the entire bid for a lease of land into a Section 16 procurement for services.
Is there language in Section 16 that says it won't, in Section 6 that says it won't apply to transactions involving real estate?
It does not. It just applies to services. I believe the Warfali case from the appeals court makes that clear, that Section 6 applies only to goods and services and distinguishes that from a lease of land under Section 16.
And does Section 6 say that the services, because I didn't see didn't see services language. Does Section 6, I didn't see that it said it was limited to services. It just says officer may enter into procurement contracts.
Right, so that would be to obtain some service to the MVAC.
Service or good.
Right, so you naturally assume that an RFP issued under that section would actually involve the MVAC paying money to obtain services in exchange rather than seeking rent.
Services, you keep saying services, but it can't be goods?
Yes, it could be goods under Section 6 as well.
And under Section 6, it needs to be services or goods for the municipality?
Yes, to the governmental agency issuing the bid. So, having established that this bid should have been considered under Section 16, the standard is very deferential to the commission here. There must be some rational basis for the award. And we submit that the price differential alone between the two bids suffices as a rational basis here. There is a procedural issue under Section 16, and that's the MVAC's failure to open the bids in public. We acknowledge that this occurred. This was an inadvertent error, and there's no evidence in the record that any of the bids were tampered with in any way. There's cases from the Superior Court, Attorney General's bid protests, and several other jurisdictions supporting that failure to open bids in public under Section 16 shouldn't result in invalidation of the bid. And in each of those cases, the tribunal didn't put process over substance.
Are there no appellate cases here to that effect?
No. There are not. There's the Schiaba case, which is an appellate decision that doesn't apply to opening the bids in public, but makes this distinction between technical and substantive errors under Chapter 30B. I'd like to move to the MVAC's counterclaims unless the justices have any other questions for me on airport fuels claims. Turning to those counterclaims, the Superior Court held that the MVAC's breach of lease Chapter 93A claims against AFS and its claims against the guarantor of the lease, John Kahiri, were barred by res judicata because of the MVAC's summary process action. But the district court did not decline to award damages, as the Superior Court appeared to believe it actually preserved the damages question for Superior Court.
Was he saying, though, basically that you should have brought those claims in the other case and you didn't?
We had already brought those claims in the other case. We had filed counterclaims in the Superior Court. The district court was aware of that fact and then noted that because of that, it was declining jurisdiction over the claims, noting that they're obviously preserved for a hearing before a jury in the Superior Court.
So timing-wise, I wasn't really clear what suit was filed when, or when did you assert the breach of lease and 93A claims in the Superior Court? And was that earlier or later than the district court?
Half and half. So the MVAC filed its counterclaims in this matter, except for the Chapter 93A claims, prior to the summary process action. Then it filed the summary process action, which was decided in early June. Once the statutory timeframe for the Chapter 93A notice letter had passed, the MVAC amended its counterclaims to include that as one of the counterclaims.
Its counterclaims in the
Superior Court action, yes.
And their argument basically is that what you're really challenging is a breach of lease, and that's not an unfair and deceptive act or practice, breach of contract. So what's your response to that?
Yes, under Chapter 93A, they have indeed argued that a mere breach of contract is not subject to Chapter 93A liability. This was not a mere breach of a contract. AFS remained without right on the property. It knew its lease had expired and another tenant was waiting to move in, and it also knew that it was about to generate a huge profit from its activities on the vineyard during the busiest time of year. This conduct fits squarely under Anthony's Pier 4, which holds that a party who breaches a contract in a deliberate attempt to obtain the benefits of the contract, here the profits, and to avoid fulfilling its own obligations under it, here the obligation to vacate, is liable under Chapter 93A. Frankly,
Why would they be liable to you, though? Because Depot's the one who's hurt, not you, not MVAC.
The benefit of your bargain you continued to get because they paid the rent.
Right. And there's case law. This is where we get into, I think, an area of law that Massachusetts courts haven't quite considered yet. Typically, the remedy for the landowner in this situation is just fair market value rent for the period of the tenancy at sufferance. There's authority in the restatement of restitution holding that a conscious wrongdoer in this situation, like airport fuel, should be punished with disgorgement of profits. And frankly, if you think about it, this makes common sense as well, because otherwise there's no incentive for a commercial tenant like Airport Fuel to vacate the property until the summary process action kind of completes its course, because it knows it can just continue paying rent and making that additional profit. So this is a deterrent.
Was there a cross-claim brought by Depot?
There were a few counterclaims brought by Depot Corner.
What happened to those?
I believe they were voluntarily dismissed so that we could get this case up on appeal. The last point I was just going to make on that is that there's a 2013 SJC decision in Tyler noting that disgorgement of profits is appropriate in a Chapter 93A claim because such a damage award would remove any financial incentive to violate the law, and the same principles should apply here. Any other result, as the restatement points out, would effectively legitimize a private and eminent domain in favor of the wrongdoer. In conclusion, I know my time is running short. I want to make our request of this court clear. The MVAC asks that this court uphold the trial court's rulings on AFS's claims, reverse the rulings on the MVAC's counterclaims, remand all of those back to the Superior Court for a trial on the guarantee claim. The MVAC didn't move for summary judgment on that because there are disputed issues of fact. And expert discovery and a damages hearing for the breach of lease, Chapter 93A, and unjust enrichment counterclaims.
So is this case properly here if parts of it are still below?
No, everything was fully resolved below, either by summary judgment entering or by voluntary dismissal.
And if we were to remand the counterclaims as you request, what happens to the claims that were dismissed before the appeal? Were they dismissed contingent upon some outcome of the appeal, or they were dismissed with prejudice?
They were dismissed with prejudice. Board has any other questions?
No, thank you very much.
Thank you.
It's at the end of the- Oh, yeah, that's right. I was like, I'm feeling like we're not done.
Good afternoon, Your Honors. May it please the Court, my name is Marilyn Vakota, and I represent Depot Corner Incorporated, the winner of the bid. If my client had known that they would be engaged in 4 years of litigation for winning this bid, I don't think they would consider themselves much of winners. This has been grueling, to say the least, for my client, who has expended a large sum of money to build a new gas station. You'll see in the facts that when Depot Corner had won the bid, it had the option, which was clearly set forth in the RFP, of either negotiating a purchase price for the existing improvements from the incumbent, or refusing to purchase those, or if they failing an agreement, insisting that the improvements be removed as is required by the incumbent's lease. And that's exactly what happened. The improvements were removed by the incumbent, and my client started and commenced an effort to build his own gas station, which on Martha's Vineyard is grueling because you're not just facing regular
Right,
permitting.
but what's the legal issue for us to decide here, or that you're pressing?
So I only have a couple of points to make here, just with respect to some issues that were raised earlier. As for the RFP requirements, the Section 6 versus Section 16 requirements, the Inspector General has a guidebook, and although this is not binding, the Inspector General itself acknowledges that Section 6 criterion can be used in Section 16 RFPs when disposing of excess real property and awarding authority. They have the option, but they're not required to use that criteria. For any Section 16 bid, there's a great deal of discretion that the awarding authority can use in determining what criteria they want to look at. And that's just what was done here. Although it might have been a little wonky, it is permissible.
So, but the argument we're hearing from the fuel people is that, in fact, what ends up happening is that this lease that your client signed really didn't comport with any of this, and probably was below their bid. What do you say to that?
Yeah, so that's not accurate. There was one provision that was inadvertently included in the lease. In discovery, it was clear that during the course of negotiation between the lease, we did release the negotiations, and Depot Corner had struck that provision because it was not in the original lease agreement. Since the awarding the authority and signing the lease, Depot Corner and Martha's Vineyard Commission had amended the lease, and we removed that provision altogether. So that doesn't even exist anymore. And as far as an increase...
You're talking about the market rent
Correct.
provision, okay.
Correct. The other provision that was...
Your client is paying the bidded rent.
It's actually more than that now, because the market rate actually has gone up fairly significantly. And under the MVC rules, I believe they can increase it up to 10%. The other provision that was added into the lease agreement that wasn't in the original RFP, merely addressed the litigation and the ongoing litigation, which it was necessary to provide some kind of provision in the lease agreement in the event that Depot Corner or the Martha's Vineyard Commission were required to rebid altogether. So that was the only other provision that had changed in the original lease agreement. The other point that I would like to make is that that airport fuel also cross-moved for summary judgment. So on some level, it believed that there was no issue of fact in the matter. And then finally, just on the distinction between Section 6 and 16, I spent some time thinking about, after I read the cases, trying to figure out, well, what is the difference when there is a blend? And really, I came to two conclusions. Whenever you see that there is a blend, and there are cases where it is a blend, this is not a case of first impression. There's previous cases where a court has reviewed a bid procedure that was originally Section 16, and it ended up being a blend. And in all of those cases, a couple of things are happening. Either the awarding authority or the public authority is spending money, or the awarding authority is exercising control over whatever it's having the bid on. And in this case, the only way money was flowing was to the MVC. The MVC wasn't spending any money on this, and it wasn't exercising any control like you'll see in some of those other blend cases, such as the Barassi case, where the awarding authority had all these rules about construction and what had to go there, and had actually, I think, a veto power in that case, which was not the case here. Depot Corner built exactly what it wanted to, and today it operates as a gas station paying the rent in accordance with the lease.
I don't see any further questions. Thank you all for your argument. It's an interesting case, which is now submitted. Thank you. We're going to stand in recess. I want to thank all of our court personnel, including Court Officer Guarino, and we're in recess.